to the inquiry on this day, 28th of March. And I want to indicate upfront that we are in the month of Ramadan, and I would want to take this opportunity to wish the entire Muslim community strength during this time, but also to welcome members here at M46 and on the virtual platform, to welcome the public protector, Advocate Mkhwebane. Welcome back, especially after you've made a full or better recovery from the illness. We welcome you back, to welcome your legal team led by Advocate Mpofu, evidence leaders, Advocates Bawa and Mayosi, members of the media, the entire support staff of the inquiry, as well as the members of the public. Welcome back to the inquiry from all your various platforms. We will proceed as usual. I just want to indicate upfront that in between the normal breaks, we have just plotted something between myself and Advocate Mkhwebane that we might introduce some 5 minutes stretch breaks for good reasons. So don't be surprised when we do that. So thank you very much. I therefore want to take this opportunity to invite Advocate Mpofu to take over from here and continue the testimony with Advocate Mkhwebane. Thank you very much. Over to you, Advocate Mpofu.
Thank you. Good morning, Chairperson, members and colleagues and members of the public. Chairperson, if I may, before we start, there are various issues of different degrees of seriousness, which we needed to raise, but you indicated in your letter, in the letter that we received yesterday, that we should do so either towards the end of the day. So I'll just keep in touch with you as to when the appropriate time is. Maybe when we shift to another big topic or another heading or whatever. But we do need to just flex.
That's in order.
Okay.
Thank you.
I'm putting my phone on silent, but I think I'm actually making it louder. Okay. Thanks. Thank you, Chair. Chair, I also yeah, I think we. Good morning, Public Protector.
Morning, good morning, SC. Good morning, Chairperson, committee members, evidence leaders.
Yes.
In the public.
Yes, thank you, Public Protector. And I think we also hope that you feel sufficiently better to carry on.
Yes, I think I'll try, as Chairperson said, we will.
Yes, we will do your secret deal. Okay.
How about secret?
Secret.
It's just been placed here.
Secret now. Yeah. Okay. No, thank you. PP, I just want to really, we left because we're in a bit of a hurry, and that day I had a secret deal with the Chairperson because we were chasing a flight. So I just want to round up the topic that we were busy with so that I can move to something else. So we left it kind of hanging. And just to remind, it's been more than a week since we were here. So just to remind everyone, we were busy when we finished with the issue of the referral of the allegations of money laundering to the NDPP. You remember that, PP?
Yes, I remember.
And we had just put up the two dicta, as we call it, or which is just passages from two judgments of Judge President Lambo, which seemed to be saying different things on the same topic.
Correct.
Yes. And I think my last word was to say homework for those who think that judgments can simply be transplanted, because then we wouldn't know which of those versions to take. So I just want to finish that topic with just two quick aspects. And this is really just for emphasis, or to emphasize that point, because I suspect that this issue of the role of the judgments is going to play a very prominent role. But as I said to you, the legalities around it will obviously be argued when we do the oral argument or the legal argument at the end.
Okay.
So with you, we simply just want to tease out the facts so as to create a platform for those legal arguments. And maybe it's quite important. You will remember that literally on day one, that would be the 11th of July, 2022, it became clear that ourselves, and when I say ourselves, I include you, and the evidence leaders had a fundamental difference of approach, which, as I say, will be resolved one way or the other in legal argument. And it centered around this question of the role of the judgments. They hold the view that the judgments are binding, there's nothing more to be done. And we hold the view that the judgments are here to be scrutinized and verified and inquired into, and so on and so on, without obviously detracting from the rule of stare decisis, that higher courts bind lower courts and so on. And my prediction is that, and I think you also put that in your statement, that the resolution of that issue, one way or the other, is going to be a major issue in the legal argument. That's one of the big issues. The second big issue is going to be the scope of the inquiry. You know what we mean by that. Everyone here now knows what we mean by that. Whether A, the inquiry should be confined to the recommendations of the independent panel, to the extent that it might have excluded some of the quote unquote Mazzoni motion charges, or B, whether the Mazzoni motion is to be inquired into as it is. Again, we don't have to get into that debate right now, but those seem to be some of the big issues or hurdles that we were going to have to overcome before we know what it is that this committee has to verify. Now, against that background, this issue of the judgments that we were dealing with then becomes quite important. And I would like to, before we move away from that topic, maybe ask Tsepo to put up this audio visual material, which deals with what I read out the last time. And we found it fortuitously. It's bundle H, PP folder 31.7.10. We uploaded it. Okay. It was just uploaded now before we came here. I thought it was uploaded yesterday because that's when we found it. But as I say, it's just for emphasis. We've already read this out to the committee.
Are you winning, Tshepo? Okay.
To the committee. Okay.
Interim order in paragraph 4 shall become final.
Sorry. Maybe hold on. Just okay. Chairperson, just in fairness,
Just a pause. Just a pause before you play it out.
Maybe hold on.
Please pause on it. Thank you. Advocate Mbofu.
Chair, yes, no, I just thought, for people who haven't seen this, it's easy for me because I watched it overnight. Yeah. Yes, it's just background, and it really is the point we made. I know it was more than a week ago. It's the same point. It's just a visual representation of the point we made just before we finished. So in other words, people must look out for the one statement and the later statement against each other. Thank you. Sorry, I just thought it to be easier for people.
Thank you.
Thanks, sir.
Please proceed and play the clip.
Thank you. Sorry, I just thought it to be easier for people.
Thank you.
Thanks, sir.
Please proceed and play
including the cost of two cars.
clip.
The orders of invalidity made above relating to the National Prosecuting Authority Act are referred to the Constitutional
Please proceed and play
in the premises the following order.
clip.
The orders of invalidity made above relating to the National Prosecuting Authority Act are referred to the Constitutional
Please proceed and play
in the premises the following order.
We're just hearing too many voices there.
It's me and you, and then the video at the same time.
Yeah, we want to hear Judge Mlambo. Advocate Bauer.
Chair, can I check? Are you, sorry, Chair, through you. Is this him reading out the judgment, or is this what he had to say?
No, just the order.
Just the order.
Just the relevant portion, yes.
Advocate Mbofu, can we just not read it? We've got it in front of us. The order that Advocate Mbofu
No,
reads out.
yes, no, you can. We've already done that, but we just want to use it for
The
emphasis.
sound is, it's going to be exactly the same thing, and the sound is
Let's try.
terrible.
Okay, no, fair enough. If it's
Yeah, thank you. Let's see. Can we improve the sound? Let's try again.
if it's
Yeah, thank you. Let's see. Can we improve the sound?
Inspector's report number 6
Let's try again.
of 2016-2017 dated
It's,
14
Yeah,
October
thank you.
2017.
Let's see.
And
Can we
it had
improve
to-
the sound?
Inspector's report number 6
Let's try again.
Okay,
of
what we'll
2016-2017.
okay,
Let's-
check. Can I just to save time? Because what seems to happen is that somehow the conversation between you and me is superimposed onto the video. I don't know how that happens.
I
But-
think it's because when this is on, maybe if we all switch off our mic, I don't know. So
Okay, we'll try that. Let's do it for the last time, and I'll switch off.
I don't know.
Okay, we'll try that. Let's do it for the last time, and I'll switch off.
Okay, Chair, I have an idea. I'll leave this. I'll start with another topic, and then I'll ask my team literally to resend the thing afresh. And then we ignore that one and play the new one. Yeah. Oh, okay. Thank you.
Thank you for that.
Thank you. Thanks, Chair.
You can now switch on yours, Advocate Mkhwebane. Thank you.
Right. In any event, this topic that we're dealing with, the real gist of it is the reference to section 64C of the Public Protector Act, which Ms. Bauer, I'm sure can find for us. But it's the one that deals with your power to refer to other agencies.
Is that in the Nkandla judgment?
No, just the 646, just the Public Protector Act itself.
Bundle A under the legislation.
Also paragraph 303 of my affidavit.
303.
Yes.
It's bundle C, Shepo.
With one, the actual section.
Yeah,
Okay.
go to number 1. And the 6. It's page 70.
17.
Right. Okay. Chair, I'll just read it. I'm going to go down to 64, please, Tepo. See. Yeah, all right. So, yeah. The public protector shall be competent to investigate on his or her own initiative on receipt of a complaint, any alleged, and then they list out the various things. And then C, say at a time prior to or during investigation, rather an investigation, Roman 1. If he or she is of the opinion that the facts disclose the commission of an offense by any person, to bring the matter to the notice of the relevant authority and charged with prosecutions. Now, it looks like the finding against you by the majority in the CR17 Busasa matter revolved around the interpretation of that section.
Correct.
Yes. And just to save time, I'll put it like this. Your view is that it says what it says, that if there's a commission, if you are of the opinion that there's been a commission of an offense by any person, then you would bring that matter to the notice of the NPA. I'm just paraphrasing, because the only relevant authority charged with prosecutions is the NPA, correct?
That's correct.
Right. And then the sub 2 chair says that if he or she deems it advisable to refer any matter which has a bearing on an investigation to that, or rather to the appropriate public body or authority and affected by it, or make an appropriate recommendation regarding the redress of the prejudice resulting therefrom, or make any other appropriate recommendation he or she deems expedient to the affected public body or authority. Okay, so that's a wider one where you refer any matter which has any bearing to an investigation, not necessarily criminal offense, to the relevant authority.
That's correct.
Right. Now, the view of you'll remember that Mr. Mkhwebane's complaint involved in the case we're dealing with, involved suspicions or allegations, let's say, of money laundering.
That's correct.
Right. And let's put aside now, there's a debate about whether it falls under PRECA or POCA. We'll come to that. It seems like in the report, the wrong statute was referred to, but I don't think that's a major issue. A crime, let's just say it's a crime. Money laundering is a crime, correct?
That's correct.
Yeah. And can you then explain to the committee on what basis, using what we have seen, you made the remedial action, which was for the investigation of the alleged money laundering claims against the president?
Yes, in the report, we in fact mentioned, or we also attached the letter which was from the complainant directly. And also the good thing was that to show that the complainant was also saying they suspect there might be issues of money laundering, the way the money was transferred from one account to another account. So during our investigation, the evidence which was before us was showing that indeed there was indeed a lot of money which was moving from one account to another account. And then as you would see, that section 6 subsection 4 is very clear that either during the investigation or at the completion of the investigation. So it is possible for the public protector during the investigation, even before the investigation is complete, to refer the matter to another authority, whilst continuing possibly with other matters which are falling within their mandate. But then in this case of the CR17 investigation or Busasa investigation, we completed the investigation and then we referred the alleged issues of the claim or the allegation that there might be issues of money laundering or there might be any criminal element. So hence, in this instance, we referred the matter to the relevant institution, which is responsible for prosecution, which is the National Prosecutions Authority. So other matters we do refer to also the Hawks. During our investigation or at the completion of the investigation. And I think that's what I said, that sometimes people have a wrong perception that possibly as the Hawks or any other institution, they might not proceed with their matter or investigation until the public protector finalizes the matter. But then that doesn't stop any other institution to proceed with any other matter if the matter is before them per their mandate.
Right. And just to be sure, the reference bundle E item 10 number 1, please. That's the Busasa report.
And while still looking for it, again, besides what the complaint was all about, then take it further to what the public protector is expected or learning from the male and guardian judgment.
Yes.
That the public protector should have an inquiring mind and not only be restricted in the investigation.
Right. Now, if you go to page 17 at SEPA. against CC.
Page 17.
Yes. Okay, I want to read that out just to save time. That's basically where you make a recommendation, or rather a finding, and reference it to the section that we just read out to the committee. 64C Roman 1,
Yes.
correct? Yeah.
This was relating to the issue of regarding whether there is an improper relationship between the president, Ramaphosa and his family on the one side, and the company African Global Operations on the other side, due to the nature of the 500,000 payment passing through several intermediaries
Yes.
instead of a straightforward donation to the CR17 campaign, thus raising the suspicion of money laundering.
Yes.
So I must also upfront say to the committee members, chairperson, and I think this process is also, as I indicated last week, that it's for the benefit of the public. And I think hence sometimes I would prefer that we read and also educate not only the public, but even public servants to know when we investigate, we deal with issues. So in this matter, when we receive that complaint of Mr. Mkhwebane, it's in on page 8 of our report. And we then had to go through that letter. I think, sorry, SC and chairperson, if you go to page 8, Tsepo, because we also adopted the issue of also just showing that this is the complaint which we've received, because some implicated parties might say to us, but who has complained? I just want to see the complaint. So putting it in the report at least also shows that these were the issues which were raised, but then doesn't restrict us because we can go beyond these issues. So that's where there was mention of the money passing through. So when you pick up that, then you can indicate that we've got the following 2-3 issues we are investigating. So under each issue, let's see if you can give me an opportunity to explain. Under each issue,
The chair will give you that opportunity.
Thank you.
Please proceed.
Sorry, the chair is more patient.
Don't be intimidated by him.
I see, I think SC is under pressure because they said the time, but I prefer that at least people must understand.
Perfect.
Because when we receive such a letter, there is an assessment. Then we determine, because this will help us in the freedom matter as well as SC. Then we determine which issues we are investigating. So after receiving this complaint, then we say we've got 3 issues or 4 issues we are investigating. And under each issue, we need to determine what happened, what should have happened, what laws have been violated, and how to address the gap between the two, so that we uproot the root causes, and then so that we can remedy that. So under this issue, because there were 3 issues which we've identified under the Bosasa matter. So it was then the issue of the questions responding to Parliament about the son. The second one was relating to the violation of the Executive Members Ethics Act concerning the exposure to a risk of a conflict. Then the third one was relating to the improper relationship between the president, his family, and African Global Operations, or Bosasa. And then that's the one which you asked now. And this is the one where after the investigation and the evidence and the bank statements, we've analyzed the then reflection of this 500,000, but then as well from Mioto to EFG to this linked in company, and then how the money was moving. Hence, there was a need to refer this matter to the NPA, which is what you've just read now.
Okay, thank you. I think no need to you could see that I wanted to move on, but I think it's important that the chair allowed for that background. although it covers some of the ground we had already covered, it just situates the evidence. Yeah. Let me do it like this again. As I say, I'm trying to run with this. So you remember that we had a discussion, I almost said on Friday. Well, it was a Friday, but not last Friday. It was actually a Thursday, yeah. That we had a discussion about the structure of your powers. Simple. Investigate, make findings, you report, you remedy. And we explained that remedy means literally curing, as you've just said,
root causes.
the whatever it is that the complaint was. We even use the medical example. So the patient is the complainant. They say this and that is wrong. You investigate to see if that is indeed so, and then you prescribe the medicine, which is the remedy. Okay, that's fine. Okay, that's good for background. But I wanted us to zoom into this specific issue of money laundering. And I think you've already covered it, so we don't have to go back to that. You've said that it's not something that just came from your head. It emanated from Mr. Mkhwebane's complaint. Yeah. And it involved what I think the last time I called it round tripping. In summary, he was basically saying, because the money went to this one and that one and that one, then there's a suspicion of money laundering.
Correct.
Right.
Yes.
And based on your findings, then you made the recommendation, not the recommendation, the remedial action, which you will find, Chair, at page 19.
Of the report,
of
page
the report,
18. Yeah.
Is it 18 or 19?
19.
It says 19.
19 against AA.
Okay.
And this is what you were criticized for. I mean, this is one of the issues that you're supposed to be impeached for. Yeah, sorry, it's my mistake. Yeah,
She was complaining.
Yes, no, this time it was my fault. So Tsepo is wide awake.
Advocate Mpofu, it's always your fault.
I know. Okay, against AA, and this is what it says. Really, all you did was to make this recommendation, and you should be impeached. It says, within 30 working days of receipt of this report, the National Director of Public Prosecutions is to take note of the observations contained in 7.3.1, you've already referred to that, as well as the recommendations contained in paragraph 7.3.3 of this report. That's where you confirm Mr. Mkhwebane's allegations as having a prima facie basis. And in line with section 64C1, which we just read now, of the Public Protector Act, to conduct further investigation into the prima facie evidence of money laundering as uncovered during my investigation and deal with it accordingly. Now, I think the simple question is, for making that recommendation, is there anything to your knowledge of the law and of your powers that is outside the scope of your powers that you are doing? In other words, were you finding anyone guilty, or were you prescribing to the NDPP to find someone guilty or even to charge them? What were you doing by making that remedial action?
No, I was not at all, because I don't have the mandate to investigate criminal conduct or criminal matters.
Mm-hmm.
The powers and the mandate of the public protector from the Constitution is to investigate improper conduct in state affairs and remedy that. So in this instance, I don't have jurisdiction to investigate criminal conduct, money laundering, or suspicion of money laundering. And when I say this prima facie case to investigate this, it was based on the evidence before me, which is the bank statements and how the money was moving from one account to the other account. So I couldn't, or we couldn't just ignore the fact that the money was paid into an account and it moved from one account to the other. And I must indicate, SC, that again, from the very same judgment of Unkan state of capture judgment, the one we're still going to deal with, of Chief Justice Judge President Mlambo. What we also picked up, and we also mentioned in all our reports, was that they even went further and say the public protector can even only investigate and issue a report of referral, or the public protector can investigate, have findings, and not take a remedy, but then that is also binding, that even observations are binding, which is one thing which we were not doing, but through that judgment, we also then took that into consideration, or the development of jurisdiction or jurisprudence. So this is all which I did. I was not finding any person guilty. I was just saying there's this evidence in NPA. This is your constitutional mandate. Can you look into the matter? And again, looking into the previous judgment of state of capture, where the judge president said there is nothing in the wrong for the public protector to refer the matter to other organs of state.
Thank you. Yes. Yeah, that's where the bite really of what I'm dealing with is. In other words, to your knowledge, was what you are doing here any different from the referral for further investigation by the NPA that was done in relation to the state of capture report?
Nothing at all. I mean, if you, we will have to possibly just go through to the state of capture report, and you'd see exactly the same section was utilized. The court pronounced that there's nothing wrong in what the public protector has done, because the legislation, the public protector legislation, which gives the public protector additional powers, empowers the public protector to do exactly that.
Yes. And I think we're going to do the second try of the video. If we fail this time, we won't do it. But the emphasis on it is that you had you are fortified by your interpretation of 641C1 that we just went out, but that we just put up for the members. But you are also fortified by the trying to avoid the Latin. Yeah, you are fortified by the articulations of Judge President Mlambo in the state of capture judgment, correct?
Correct, Chairperson. I think this process is also for the public. The public is watching, and I think it's very critical for them to see that video. But secondly, also the students, I know they are watching, so you should also be using that Latin word so that they can learn and know. Yes.
Well, yeah. Okay.
Yeah.
I think the last time we tried to speak in Latin in this room.
No, but you are educating.
All right. If I do that, okay, that's fine. Thanks. If I do that, then I'll also translate it into simple language.
Yes.
I hate Latin. Okay. So, all right. Tsepo, can we try 31.7.10.1? That's now the re-uploaded. It's also been emailed to you if that doesn't work.
Whilst we trying to fix this, thank you.
Thanks, Chair.
We pause.
Recording stopped.
We're back exactly 5 minutes after, and the people would have been back before that 5 minutes, but her beneficiaries of that break, some are still outside. Thank you. We proceed. Advocate Mbovu.
Thank you, Chairperson. Yes. All right, can we go straight into the video before it misbehaves again? Chairperson, yes. All right, can we go straight into the video before it misbehaves again?
Interim order in paragraph 4
Yes.
shall become final.
All right, can we go
The
straight
President,
into
the
the video
Minister of
before it
Justice,
misbehaves again?
Is dismissed. It is declared.
interim order in paragraph 4 shall become final. The President, the Minister of Justice, and the National Prosecuting Authority shall pay the applicant's costs, including the cost of tutor. The orders of invalidity made above relating to the National Prosecuting Authority Act are referred to the Constitutional Court paying the applicant's costs,
In the premise,
including the cost of
made.
the application of invalidity made above relating to the National
declared that
Prosecuting
the immediate
Authority Act
action in the
are referred to the Constitutional Court paying the applicant's costs,
in the premise, October 2017,
the application of invalidity made above relating to the National Prosecuting Authority Act are referred to the Constitutional Court paying.
That's short. It's almost done, but obviously we'll have to try some other time. But I just want to assure you that whenever it is, it will be a minute or two. Yeah. Thank you, Chair. All right. Now, PP, looks like either the IT people are I'll leave the judgment of the IT people to the chair. But yes, now just to round off the point. So you have this scenario. Honorable Sukas, I think, his favorite point is about learning from judgments in order to have what we know as continual improvement, which any manager knows is that's how you learn. I think the guru international is a person called Peter Senge, whose book is called The Learning Organization. So an organization must learn from its mistakes. Otherwise, it will never grow. And the point really, which is crucial to this commission, to this committee, is how then would you, if you are a public protector, you come into office, you're armed with a judgment of one judge, which says, yes, you may refer a matter to the NPA in terms of section 641C. And just for dramatic effect, we argued that I was in that case. And our opponents were saying, no, the public protector can't encroach into the independence of the NPA and what have you. And we said, no, in terms of section 41C, that's exactly, as long as you don't prescribe, you don't say you must charge this person. In other words, if the NPA investigates and they find that there's no case, you have nothing to do with it. You would have done, in any event, you'll be functus officio. And we succeeded in that argument. And then you did the same thing a few years later, I think in 2019 or 2020. And then you are told by the same judge that no, it's a sign of irrationality and all sorts of things. What does that do to your ability to execute your functions?
You know, that creates a lot of confusion in how we operate as an institution, because indeed, as a learning organization, and again, repeating that each and every report of the Public Protector, I mean, if you check the reports I issued when I joined in let's check the reports of my predecessor compared to my the reports I issued 2016, improving 2017, improving 2018, to show that we are a learning organization, and as well, learning from the jurisprudence which the courts are there for. Now you find this particular matter where we investigated the matter, knowing that I don't have jurisdiction over criminal conduct, and this matter should be referred to the National Prosecution Authority for them to look into the matter. And I think you've seen how I've crafted or how that remedial action is crafted by the investigation team, which I agreed to, because at the end of the day, that's what I agreed to. But it creates a lot of confusion. I mean, in Sepedi ba re ke kgomo ya moshate. Wa e kgapa o molato, wa e tlogela o molato, meaning whatever you do, you are wrong. Hence, I'm sitting here. The independent panel said I should be accounting for how I dealt with that investigation of Busasa. And I think this is an opportunity for me then to show the public or anyone who cares to listen that this is the provision of the Public Protector Act. This is what the same court under the same judge president who said during my predecessor's time or my predecessor's report against President Zuma, there's nothing in the Public Protector Act which prevents the Public Protector to refer the matter to the NPA. But then under my term of office and investigating again the president, using the same legislation, the same provision, referring this matter to the NPA, then I'm being criticized that I'm encroaching on the independence of the National Prosecution Authority. And unfortunately, that's not our intention as an institution. Now this puts me or puts us in a predicament. Maybe then the next Public Protector will be lucky enough, possibly would not be treated the way I was treated. I don't know which, when I hand over to that person or when that person continues to do their work as the Public Protector, what do we say to this section 6, subsection 4, C, Roman figure 1? Must the person refer the matters, or must the person, what should happen? Because then the courts, if they say you cannot do that as the Public Protector. So I think that's a very confusing situation. And again, I would normally say I pity the students who are still at various universities. As a law students, we rely a lot on court judgments. That's where we learn. That's where we learn the interpretation of statutes, and courts bring life to what is written in any legislation. So that creates a lot of confusion. And I must indicate that indeed we took the judgment, we incorporated in our various reports what the judgment has been saying, as I said earlier. Thanks.
Right. All right. And well, I think maybe just to place you then as in the context of a learning organization, in this case, you are the student, quote unquote. So is in this then the situation where the teacher tells you on Monday that 1 + 1 is 2, and then on Tuesday they tell you no, 1 + 1 is now 5. So, and then if you fail at the end of the year, can we blame the student or should we blame the teacher?
definitely we'll have to blame the teacher because, I mean, whatever the teacher says goes. And indeed, you can't blame that particular students because they were told, I mean, it's a position of authority. Me respecting the judges and the judiciary and learning from, because it's their specialty and they are guiding us. And I mean, being an institution which is having or operating under the rule of law, that's what I thought we should be doing. But now I don't know which way to follow. Yeah.
All right. Now, thank you, Chair. If I have the stamina, I'll come back to the video at some other time, but I want to move on.
We're flexible on that.
Thank you very much, Chair. Right. Now, PP, again, without taking you back to the legal debates, I want, for the next section, I'm going to take you to the findings of the public, of the independent panel on the, specifically on the CR17 matter. Because if we are right, that's really what we have to zoom into. It's those issues that they identified. But if we're wrong, of course, which is why we dealt with the bigger picture as well, then at least we've covered those issues. But I now want to zoom into the issues that were specifically identified by the independent panel. And before I do that, Chair, if I may, just for context, can you go to page 822 of the independent panel report, Seppo, which I'm sorry. It's paragraph 81, because the big page 822 might be different from person to person. Paragraph 81. Printed page 30, that's correct, Chair. But it's a bundle A. 10397. Yeah, page 30.
Page 30 of that report,
Of the actual
paragraph 81.
Yes, thank you, Chair. Yeah, page 30.
Page 30 of that report,
Of the actual
paragraph 81.
Yes, thank you, Chair. That's what you call a concurring judgment.
So it's clear there's nothing wrong with the clip.
Yes, it's the people.
Yeah, let's pick something up there. Problem there. Now know the clip
What you call a
is,
concurring judgment.
so it's clear there's nothing wrong with the clip.
Yes, it's the people.
Yeah, let's pick something up there. Problem there. Now know the clip
What you call a
is,
concurring judgment.
so it's clear there's nothing wrong with the clip.
Yes, it's the people.
Yeah, let's pick something up there. Problem there. Now know the clip is,
Okay, so IT must
nothing wrong with the clip.
function or resign. All right, paragraph 81. I'll just read it out. IT must, if function or resign. All right, paragraph 81.
IT up there, we have an echo, and there's nobody talking here for us to have that echo. So please try and fix it. Let's try again, Advocate Mbofo.
Thank you, Chair. I'll just read it out. If
for us to
this
have
is what
that.
the independent panel said.
So please try and fix it. Let's try again, Advocate Mbofo.
Thank you, Chair. I'll just read it out. If
for us to
This is what
avoid.
the independent
Let's
panel
just
said.
pause it because we've got to do it properly. We
Yes,
can't
thank you,
be-
Chair.
They just walking down. Just don't know whether figure about in up and down, but I come machines up. I'm interested. Can we try? I'm going to so the problem was with the table.
Yeah.
No, but you just come to fix it with your laptop. Please don't be in denial. Proceed, Advocate Mpofu.
Thank you, Chair. All right, I'll read it out. Paragraph 81. It says, if on the evidence before this panel, which consists primarily of reports, court pleadings in the form of affidavits and judgments, it is found that the information provided by the member, that would be Ms. Mazoni, considered against the constitutional and legislative backdrop, does not establish prima facie evidence of misconduct, incapacity, or incompetence to warrant a recommendation to the Speaker of the National Assembly to appoint a committee to commence a Section 194 inquiry, then in that event, there will be no such recommendation. Conversely, if it does establish prima facie evidence, then an appropriate recommendation will be made. What is your understanding of that? What happens if the no prima facie evidence is found? And the simplest way to do this is assume there's one charge. Assume there was one charge of this referral to the NPA. And then if the independent panel found that there's no prima facie evidence, what should happen? And if it does find that there is prima facie evidence, what should happen?
My understanding of this is that if indeed there's evidence which determine that there's prima facie evidence of misconduct, incapacity, or incompetence, they will then make a recommendation to the Speaker to establish or to commence a Section 194 inquiry. But then if there's no such recommendation, if it does establish prima facie evidence, then an appropriate remedial action will be made. In other words, let's say in this instance, there's 3 charges and one of them, they say there's prima facie evidence. Then it means then there must be a committee based on that one charge. But then the other 2, there's no need because there was never a prima facie evidence to come to that particular conclusion.
Yes. And yes, and that's I think the emphasis from the independent panel is on the issue of appoint a committee. In other words, just to even have this committee in the first place, forget about what it's going to do. And let's go back to my example of one charge. There's one charge. They say if there is the evidence does not establish prima facie evidence of misconduct and so on, to warrant a recommendation to the Speaker to appoint a committee, then in that event, there will be no such recommendation. In other words, no committee will be appointed at all.
Correct.
Okay, right. Conversely, if there is, then there will be a committee. Okay, fine. All right, let's put that in mind. And if that is your understanding, that's your understanding, but we'll leave it again, as I say, for argument at the end. Now, against that background, And we know that this committee holds a different view because it says, well, whether there's prima facie evidence or not, we just go to the original charge sheet. Let's now then go to 887, Chair. I'm so sorry. I'm using my own page numbers. Sorry. Well, it's paragraph 215, Tsepo. Printed page 95 of the same report.
I think what whilst going there, it's indeed, I think we will go to that, because if that's the case, and then the committee would then focus on the matters which there is evidence before them. And having a prima facie evidence doesn't mean a person is also guilty, because then you still need to inquire on that particular matter.
Yes.
Yeah.
Correct. It's only what we call in legal terms, it's a hurdle. The prima facie evidence is a hurdle to pass. So if it was a criminal matter, it's section 174 of the Criminal Procedure Act.
Yes.
If you don't pass that hurdle, then you must be
It's a
discharged.
discharge, yes.
Okay. All right. Thanks. Thank you. Okay, I think Tsepo has found it here. Now, Chair, at least as far as the independent panel is concerned, these were the only two things that in respect of which they found prima facie evidence of misconduct. Remember, there's misconduct and there's incompetence. Yeah.
Yes.
So as far as misconduct is concerned, the only two things that the independent panel found prima facie evidence on our interpretation. On the interpretation of the evidence leaders and the committee, it's everything that's in the Mazone motion. But on our interpretation, it's only these two things, okay? And these are, it says, we find prima facie evidence of misconduct in the sense of an intentional or a gross negligent failure to meet the standard of behavior or conduct expected to a holder of public office in respect of the CR17 report for the following reasons. One, the findings against the president on the issue of money laundering. That's the one we just discussed now, right? And two, the PP's doubting the bona fides of the president without reason and her failure to have an open mind on the issues to be determined. That's it.
Correct.
Right? Yeah. Okay. So if we prevail in the end, those are the two issues of misconduct that you'll be facing, at least before this committee, that you'll be legitimately facing. Okay. And I just want to say now, with that background in mind, that the issue of the doubting of the bona fides of the president, I think we dealt with exhaustively, Chair, in the last session when we were here. We went through the minority judgment of Mkhwebane Chief Justice, who I think we all agreed put it much stronger than you. You might have doubted the bona fides of the president, but the Chief Justice basically said he lied. He gave a false account of the events.
That's correct. Yes, I think with our investigation showing the or with the evidence before us, that there was indeed, especially firstly the responses in Parliament, which it's all over, it's still there in the archives, how he responded, the letter he wrote to the speaker correcting the matter and even confirming himself that it was relating to the CR17 campaign. Then the confirmation by all those we interviewed, the CR17 campaigns manager, Mr. Chauke, the others, Done and Mutlatsi. And as well, the confirmation that they hosted those gala dinners, or where they invited the donors, and one of the donors being Mr. Gavin Watson, who confirmed the 500,000 and who also attended one of those events. So the evidence was there in the report where we captured the information. We availed the audio recordings to the court, and indeed all that evidence was before us. Then the issue of the emails to show that he personally sent emails, or he was sent emails by Done. He also sent emails to the prospective donors to facilitate, and we've shared those emails last week. So the evidence was then leading us to that. I think it's true what you're saying, that Chief Justice Mkhwebane then said, instead of addressing this issue, he's worried about where did you get the emails. So it was not doubting, but it was the evidence, and based on the complaint lodged by Mr. Maimane, the investigation by the investigators, and the finalization of the matter. Indeed, that then, I would say that prima facie finding or recommendation has no basis, because we were basing our investigation on evidence, which is still out there. And the judgment of Mkhwebane, which was also very stronger, or put it very stronger than us.
Yeah. And again, we won't go there because I think we went there extensively last time.
Yes.
But for just to recap, the email information, which you say belied the denial of knowledge, was there ever a stage where the president said, no, the content of the email is wrong?
Not at all. And I think,
sorry, I think there's one email where she signed, it says, take this money, put it there or whatever, Cyril. Did you ever say, no, that was not me, maybe it's another Cyril, or, I don't know anything about this transaction?
not at all. In fact, that's where the Chief Justice was even saying we should have also then given them an opportunity to comment on that. But then when the matter was then before court, there was no way where they were disputing that this email was not from Mr. The President. And it was sent to Donald, where he was saying the 75 million should be shifted to Reatenda. And as I said, the Reatenda Trust account was the one which was a lot of monies which were transferred to this account. And one of the directors we've mentioned last week was Ms. Nchaveni as the director of this trust account.
Yes, Reatenda, yes. The sole director was Ms. Nkumbuso Chabeni, who's now, after the reshuffle, the minister in the presidency in charge of security, or our security.
Yes.
All right. Okay, nothing. So that then would take care that, and whatever we did in the when we were last here, then deals with 215.2, the issue of the basis upon which you doubted, to put it mildly, the bona fides of the president. So the part really
Not at all. Actually, I indicated last week, even going to the president to deliver the letter, the allegations letter, going back again to take the president through the Section 7(9) notice, and the recording as well we've shared with the committee, where I took him through the Section 7(9) and gave him an opportunity to respond. He requested that he'll respond in writing. That was done. So it was a process where one was giving the president an opportunity to do that, not doubting him at all.
No, but I thought your finding was that his version was not true. to put it
Definitely.
blunt.
Well, yes. After the evidence was presented to him, after the OD or the giving him an opportunity to give us contrary evidence to what we had and what the campaigns managers were saying, that he was saying no, he didn't know the donors, but now with the evidence before us, it was showing that it's not true.
Yes.
Because we had to weigh that. Remember, when we listen to your side of the story, we check with what we have or the evidence we have before us. And once we do that, when we bring it to you through section 7, subsection 9, we are saying we have the following findings against you. Yes.
No, but I think that's what the independent panel means, that when they say doubting his bona fides, that you disbelieved him, you disbelieved his version.
Based on the evidence.
Yes.
Which is not true. I don't agree with them, because the evidence before us was weighing more than against the president, actually.
All right. Okay. But maybe we're talking at cross purposes.
No,
I think
she agrees with you
Yeah.
that
Yes.
she disbelieved was, and she was basing that on what she
evidence.
had.
Yes. Okay, perfect. Then maybe to clarify, Chair, thank you, is the following two words, say, doubting the bona fides of the president or disbelieving him or whatever it is without reason. That's really the crux of what they're accusing you of. And as the chair just explains, that's the part you are disputing. That you in your view, you had valid reasons, and I think you've already explained that.
The first part, I had valid reasons. And then the second part, failure to have an open mind on issues to be determined.
Yes.
That's not correct as well. You remember I spoke about how we conduct investigations. Even this matter was allocated to a chief investigator. I was investigating with him, and they have experience in the field. They are the ones who then proposed these 3 issues which are referred to, which I said, they then said, these are the 3 issues based on the complaint of Mr. Mkhwebane. We have identified the following 3 issues, which I agreed with. So it was an open mind kind of investigation. And at any rate, independently sourcing the information, the investigators, analyzing the evidence, and then I agreed with them because they also convinced me that these are the issues we are going to deal with. But because we don't have jurisdiction over criminal matters, Section 6, subsection 4 allows us to refer the matter to any other authority, which that's what we, so I don't agree with the fact that it was not an open mind kind of investigation, or we dealt with issues with that issue of possibly trying to find anything wrong, no matter what the circumstances.
No matter what the evidence points to.
Exactly.
Good. Now, before we go back to the issue of money laundering, because I really want us to dispose of these 2 issues, at least your version must be clear to the committee on these 2 issues here. Just tell me how this works. The evidence was led here by Mr. Mataboge, undisputed evidence that he disbelieved the president's version based on the evidence that was before him. Remember that?
Yes, correct.
That in fact, he agreed with the analysis of the Chief Justice that this was just a pack of lies, and the fact that the president did not know who the donors were, or benefit personally, that those he did not believe those two aspects, because those are the two pillars of the whole CR 17 thing. It's personal benefit and knowledge, right?
Correct.
Yeah. So that's Mr. Mataboga, and nobody says that he's working nicely at the Public Protector's Office. Then you have the Chief Justice of the country. He also does not believe the version of the president, and he says it's a pack of lies, and uses all the strong words that we read out the last time we were here. And then there's you. So you're in a company of three. You also don't believe the president, you disbelieve him, and so on and so on. Now, in terms of the rules of basic fairness, if there are three persons, three independent persons, one of them is a Chief Justice, the other one is a bona fide official of the Public Protector's Office, and then you. How does it work that you must be impeached for believing or for espousing the exact same view that, given the same evidence, the Chief Justice finds, or not even the exact, a better view, a milder view than what the Chief Justice concludes, and Mr. Mataboga? Can you just comment on that? Because that's going to be one of the issues we're going to deal with when we argue this point.
Chairperson, that's why sometimes I would say I am being targeted. I am being victimized for honestly doing my work, because I think, giving very simple explanations to members of the public who are out there. Hence, I said this process is good, because it's for me to indicate that with the evidence before the investigating teams. And I was glad that Mr. Mataboga agreed to come and give evidence, and thanks to you, Chairperson, to make sure that at least the person who was investigating the matter, so that the public and even members of the committee can understand that you have very experienced investigators who will investigate the matter. And as well, I was convinced, not only by him saying there's this information which is out there, because definitely we don't at all rely on media reports. We use those as information which leads us to the evidence. So when we got the evidence and subpoenaed the bank statement, which was reflecting that indeed there is this money. I mean, Wes, even the campaigns managers, they confirmed that the money was received. The president himself, he never denied that he received the money. And the fact that we had the bank statements which we analyzed and we incorporated in our Section 7(9) notice, informing him. So I feel very victimized, or I feel that, whatever I did, and the best I know how, that's what I would say to the staff. Do your best and don't be, threatened by whatever reports are out there, because at the end of the day, you are made to be this person who is alleged to be targeting certain individuals. And that's not the case. Unfortunately, in South Africa, again, if you have a mainstream media which will perpetuate a narration that you are this incompetent person, you don't know your work, you don't know the law, then it's a manufactured concern because it's repeated over and over, irrespective of what you do. I mean, I think we're still going to take the public through the good work which I did with the public. And it's not only this work which has been done, taking as well the learnings from the Nkandla judgment that the president is a constitutional being. The president should, behave himself in an ethical manner. There should be transparency, accountability, openness. So now it's an issue that you can't touch the president, and we are there as an institution to assist in the issue of good governance in this country. But I must indicate that it makes me feel as if then I am being persecuted for doing my work.
Yes. I think we established from Mr. Matabuche that for holding the exact same view as you did on this issue, he was never subjected to any disciplinary action. And to your knowledge, was the Chief Justice, did anyone ever suggest that he must be impeached for agreeing with you?
Not at all. And I think there won't be any reason. I wouldn't even subject Mr. Matabuche to any disciplinary action because Mr. Matabuche followed the law. I mean, operated or investigated the matter purely with an open mind. The evidence before him, the complaint, the interview of various individuals, the response by the president to our Section 7(9) notice. It was very convincing. I mean, the Chief Justice, one thing about this as well, similar to the CX matter, which we'll deal with, that showed the credibility and the way the Chief Justice applied his mind on the evidence before him, irrespective of what it was said. Because remember, when those pleadings were exchanged, the Rule 53 record, so you would see that he went through all the documents and then he came to the conclusion. So I think that's what should be the case, because I mean, we do our work within the rule of law, within what the Constitution is expecting of us.
Yes. Maybe let me put it like this, because in our human condition, sometimes, we say, we do things, but upon reflection, with the benefit of hindsight, you might say, oh, well, now that you put it that way, and so on and so on. That's just human nature. So I want to ask you straight, sitting there where you're sitting now, today, given the evidence that was before you, given the responses that were given all the material that you had, starting from the complaint to the end, do you believe that President Ramaphosa did not know the donors who gave those hundreds of millions or close to 1 billion or more than 1 billion rand to the CR17 EFG account?
Not at all. Well, he knew. I don't believe that he didn't. What should I do with these emails? What should I do with the one of the donors I've interviewed who confirmed, thanks that we had the recording, it's still there, where he was confirming that he donated, he attended a gala dinner.
Mm.
So I don't know how to explain to any other person, but even a primary school child, if you'll explain to them that there is this issue, you have your 10th birthday party. I can explain to my grandson.
Mm.
And you call your friends to come. In fact, I call your friends to come and celebrate with you and bring gifts.
Mm.
And then tomorrow when you are asked, you will then say, no, I didn't know what was the matter all about. And I don't think that was all. And you accepted yourself that the money was for the that is also one of the key issues, because he said to the speaker, that money was not for my son. That money was for my CR17. It was for CR17 campaign. And I think, yes, being told by Bejane, Chauke, and even Donna also corrected him that that EFG2 account is the one which we opened that the people can donate to. So he knew about the fact that people are donating to that and who are the donors to that particular account. So I will still repeat that. And I mean, history will judge me according to what I have, and the report is there, the evidence is there, which proves that he knew that who were the donors. And I don't agree with the panel conclusion or recommendation, or what they are saying, that I doubted him. It was not an open mind. And as well, I don't agree with the way the charge has been crafted. I think we dealt with it, or will deal with it, that I was targeting or intentionally having to find anything against the president. I never, it was never my intention.
Thank you. And just for the sake of completion, do you sitting there believe that the president, as deputy president then, did not personally benefit from these donations that you're saying he knew about?
I don't agree to that notion that he didn't benefit personally. I know the courts are saying that, but then firstly, he said it's for my CR17 campaign to become the president of the country. And by then he was the deputy president. And he was supposed to even declare those donations to Parliament, because he was a member of Parliament as the deputy president. And indeed, he benefited because he was appointed as the president. That's why I agree with what Justice Mkhwebane is saying, Chief Justice, because definitely he benefited. It's just a clear and issue which doesn't need any
Genius.
yes, to explain that.
All right. Now, all right, Chair, I'm going to go to another section of the report. So I don't know if you want to take your break now. Thanks.
I do. That will be helpful. I was also hoping that we'll try that 1 minute clip for the last time so that you get it out of the way.
Yes.
Now that we know where the problem was, that it was with Tsepo. Do you mind trying it, Tsepo? So that we
Yes,
do that, and then thereafter we'll go for a tea break for 10 minutes.
I think it's need legal representation.
The President, the Minister of Justice, and the National Prosecuting Authority shall pay the applicant's costs, including the cost of 2 candidates. The orders of invalidity made above relating to the National Prosecuting Authority Act are referred to the Constitutional Court. In the premises, the following order is made. The application is dismissed. It is declared that the remedial action
we just need the volume now.
dated 14 October 2017 and entitled State of Capture is binding. The President is directed to appoint a Commission of Inquiry.
Proper, yes, just start it. Yes, There was no volume.
I'm even scared to speak, Chair, because you'll hear that voice over the.
Interim order in paragraph 4 shall become final. The President, the Minister of Justice, and the National Prosecuting Authority shall pay the applicant's costs, including the cost of two counsel. The orders of invalidity made above relating to the National Prosecuting Authority Act are referred to the Constitutional Court. In the premises, the following order is made. The application is dismissed. It is declared that the remedial action in the Public Protector's Report number 6 of 2016-2017, dated 14 October 2017, and entitled State of Capture is binding. The President is directed to appoint a Commission of Inquiry within 30 days, headed by a judge solely selected by the Chief Justice, who shall provide one name to the President. The President shall take all steps, do all things, and sign all documents which are necessary to give effect to the remedial action. Without limiting the generality of the foregoing, the President shall ensure that the judge who is to head the Commission of Inquiry is given the power to appoint his or her own staff and to investigate all the issues using the record of the... It is declared that as long as the incumbent President is in office, the Deputy President is responsible for decisions relating to the appointment, suspension, or removal of the National Director of Public Prosecutions, or in terms of... There is nothing in either the Public Protector Act or Ethics Act that prohibits the Public Protector from instructing another organ of state to conduct a further investigation. The Public Protector Act expressly empowers the Public Protector to obtain assistance in her investigations. The Public Protector Act and the NPA Act are clear that she has no power to direct the NDPP to investigate any criminal offense and how to go about doing this.
Thank you. We on that note, we take a break. For 10 minutes. We'll be back after 10 minutes. Thank you.
Thank you. Thank you. You must be tolerant with the general. He's a former dictator. He doesn't want to waste time. Thank you. I'm Mkhwebane, uyavakala.
Kuthiwa mandithule mfondisi, ufuna undifaka enxakeni.
Ndiyaxothisa. All right. Right. Public protector. Yes. Now, as I was saying that, yeah, maybe the importance of this will become clear during legal argument. But if you go to 251, Tsapo, of the same document here, I think it's 251. No, sorry, that's the wrong. Sorry, Tsapo. This time I can't blame IT. Two 209.2, paragraph 91, page 91. And I'm just going to read some of the descriptions of your alleged conduct. And at the back of the mind, just keep in mind that, as I said, both Mr. Matabucha and the Chief Justice either agreed with you or put it stronger than you. And then I'll be asking you whether, if these apply to you, then obviously they also apply to them. Okay, paragraphs. This is where the independent panel is quoting from the High Court judgment, 91. 209.2.
We start there.
Mhm.
Paragraph 65.
Yes.
That's how it starts.
The same,
Panel
yeah.
report.
Paragraph 209.2. I thought the whole idea of IT is that it must be faster than those of us who are using manual documents. Thank you. Okay, it says the following. They are now quoting from the High Court judgment. The full court held that the public protector doubted the bona fides of the president. We've gone through that. And that this quote displays a deep-seated inability or refusal to process facts before her in a logical and fair-minded manner. Now, all I'm saying is that if that description is fitting for how you assess the facts, can it also be ascribed, or should it also be ascribed to the Chief Justice, because he also came to the same conclusion as you? So that would mean he also displays a deep-seated inability or refusal to process facts before him in a logical and fair-minded manner.
It means, yes, it should be ascribed to him as well, because all the evidence which we relied on was before him when he wrote the judgment.
Let's just jump to 209.4. Full court held that the PP had not identified any evidence or facts to substantiate their conclusion that the president received direct personal sponsorship or benefited personally through the contribution made in his campaign. Do you agree with that?
I totally disagree. I mean, it's worse because the evidence was before the judges in terms of Rule 53, where every information, I take it, legal services availed all the records. And worse in this particular matter, currently we have a situation where there are those records which are sealed. And when they come and say, I have not identified any evidence or facts to substantiate my conclusion, what do they mean? Because the bank statements are there, the monies, how they flowed from one account to another account, the emails, the transcribed record of Mr. Watson, where he said I was a sponsor and I am the one who donated. I attended one of the gala dinners. So this is totally not true. I mean, it's not based on facts. And unfortunately, I'm sitting here based on this unsubstantiated information.
Yes. And then there was a whole deal made of the fact that, excuse me, the fact that in the report, whoever was drafting it, and obviously you had oversight over it, we're not running away from that. There was a reference to PRECA and as opposed to POCA. Okay, let me just say there's a reference to one act. I don't want to do the legalese. PRECA is the Prevention and Combating of Corrupt Activities Act, a well-known one that featured in Phala Phala. And then POCA is the Prevention of Organized Crime Act. Okay?
Yes.
Yeah, different acts of parliament. And in the report, when reference was sought to be made to PRECA, there was a reference to POCA, yeah, which is I don't know, I mean, where that goes, but both of them relate to criminal offenses. I don't want to get into that substance over form issue. Assuming you had referred to the correct act or the correct section. What is said is that in your identification of the money laundering allegations of Mr. Mkhwebane, and you've traced it correctly to the source, it says at 209.5 that the full court held that you, quote, completely failed, it's on the next page here, completely failed to properly analyze and understand the facts and evidence at her disposal, and showed a complete lack of basic knowledge of the law and its application. State that the full court on the money laundering issue, the PP displayed anything but an open mind, and she made serious findings based on unfounded assumptions, and that her findings were not only irrational, but indeed reckless. Now, I don't want you to go back to tracing the issue to Mr. Mkhwebane's complaint. We know what Mr. Mkhwebane had identified a specific issue about what I call round tripping. Now, you're finding that there was prima facie evidence on that and referring it to the NPA, according to what you said, showed a complete lack of basic knowledge of the law and its application, and the findings were irrational and reckless. Can you comment on that?
You know, it's so unfortunate that I think Chief Justice Mkhwebane and Justice Madlanga said it, that sometimes my mistakes are just magnified and they are made as if there's this person who is can't, you know, is always perfect. So our court and appeal systems allow the process whereby the findings of the lower courts can be overturned by the higher courts. And that is based on error of law and of facts. This is how our system functions as a country, in a democratic country where there's a rule of law and the constitution. So I'm just reading what I said in my affidavit. So it's tried that an administrative decision remains valid until reviewed and set aside. The same applies to the decisions of the public protector. They are subject to a review process. It is therefore not clear why would I be charged for misapplying the law when our system places the necessary safeguards or mechanism to correct judgments and or decisions where there has been misapplication of the law. So it is not clear to me why would misapplication of the law constitute an act of misconduct or incompetence. I mean, how many judgments which we can even take the public through, where you find that a lot of judges, there was an error of law and how they applied the law. But then are they facing an impeachment? Not at all. I mean, you find in one jurisdiction, the judge almost all of their matters, so 90% of their cases are overturned at an appeal stage. Are they being subjected to that? No, that's not the case. So, but the main focus there was that I said there is this prima facie. I'm not saying they are guilty. I said, here is the information. NPA, because that falls within your mandate. Can you investigate? So mentioning PRECA or POCA, indeed, it was a mistake which happened in mentioning that particular legislation. But the intention was, there is this suspicion of money laundering.
Right. Thank you. And
And I mean, even in courts where there's a full bench, I mean, we see in the Constitutional Court, there is a majority judgment, there is a minority judgment. So there would be different opinions and there would be application of that. And again, still coming back to say, the investigators investigating, and, you know, one, you take the report is watertight, it's fine. But then we find ourselves where we are now.
yeah. Then they go to, in fact, let me jump to 209.7, just so that we don't move from topic to topic. We'll come back to 209.6. They say the full court held that the PP displayed a clear failure to grasp the meaning of the concept of prosecutorial independence. The Public Protector Act and the National Prosecuting Authority Act are clear in that she cannot direct the NDPP to investigate any criminal offenses and how to go about doing so. Well, firstly, did you direct the NDPP on how she may investigate? And that's number one. The second question, which you can come to later, is whether there's anything with you directing or recommending to the NDPP to investigate a criminal offense.
I think the way the remedial action was crafted, it was very clear that this matter of money laundering doesn't fall within my mandate. It's a criminal act. And again, honestly focusing on what the Public Protector Act is saying, section 6, subsection 4C, that we can refer matters to a relevant authority. That's purely what I did here, referring the matter to the NPA, not encroaching on their prosecutorial independence. It's for them to decide if they feel that no, Public Protector, according to our investigation or according to how we assess this particular matter, we are not going to prosecute. I mean, normally in a lot of criminal matters, they will just nolle prosecute or say, no, we won't prosecute this matter. And that's the end of the matter. I was not at all saying to them, you must do this, how you must do it. If they feel that there's no crime committed, that's their own independent decision. So I totally disagree with this finding. And worse, it was after the state of capture judgment, the very same High Court under the very same Chief Judge President Mlambo saying, with the state of capture, there's nothing in the public protector. Even there, he was even very clear that there's nothing preventing the public protector to direct any organ of state. And now with me, especially relating to the NPA, but with me, no, I cannot do that. And I'm encroaching on the independence of the encroaching on the independence of the prosecutor, National Prosecuting Authority.
Right. And then just to complete that section, at 173, they found that it was remarkable that the public prosecutor went as far as to engage on the issue whether an answer given in the National Assembly may be clarified, as this was not raised in the complaints of Mkhwebane and Shivambu.
Again, this goes against the principle of male guardian, because one was identifying the root cause. And again, one was saying, but it's also unfair against the president. I mean, if you can listen to the audio, because I was asking him, but why did you go ahead and explain yourself when your question you were answering there was relating to VBS? Now, Mr. Mkhwebane is coming with this different matter, which is not relating to the question which was there, because the rules of parliament are very clear. Then he volunteered all this information. And for me, I was saying, then it means there's that root cause, there's a problem here. For you, Parliament, you need to reconsider your rules. You need to amend them in such a way that they accommodate this issue of correcting yourself, again, self-correcting, because you cannot have something like this. At the end of the day, he was trying to show that I can respond, I can be open, but then you are then putting yourself in trouble, and you end up not being truthful or saying the correct information. Because I'm saying to him, why didn't you say, no, Madam Speaker, I won't answer that question. Can it be put in writing? Let me go and investigate. I'll come back and respond.
Yes. Yes, isn't it?
So this was based purely on the fact of the male guardian. You cannot just see something and I just keep quiet. What's the use of the public protector? Because I must deal with the root causes of, yes, identify problems and remedy them going forward. People who would want to learn and who would understand the role of the public protector and ombudsman will work closely with us and know that at least we are having this institution, we are learning. The speaker should have taken this with an open heart. The speaker should have said, members of parliament, can we look into this particular matter? And let's check our rules. Let's amend this rule. Let's deal with it properly. Whereas, because remember yesterday, the last week I said, I was the only one who presented Mkhwebane as the public protector. And I said, besides the amendments which were proposed by my predecessor on EMIR, you need to relook into this EMIR and see whether you cannot have an issue of a first instance complaint within parliament. And if then as opposition parties, you fail to deal with the member of the executive, then when parliament fails to do that, escalate it to the public protector. We be an office of last resort, like what is currently happening with the public servants, because our act is very clear on that particular issue. So this was done in that spirit. Unfortunately, I'm then treated, or we are treated as if, and I would say we, because that's what we've been doing as an institution. I found those investigators there, and this is how we've been investigating, with a clear mind, with honesty, trying to help the country to be a better country. But then now I'm blamed why do you have, I mean, how do you, somebody was even saying with the issue of 500,000, you enter a house and then somebody is being murdered there. And then you are told, no, the husband was beating a wife. You just come and say, husband, you mustn't beat your wife. We are arresting you. You don't even, as a police, how do you enter a crime scene and then just don't look into that cops? You just arrest their husband because they are beating the wife. You don't even investigate who killed this person. But that's not how we are as public protector. And I think Mailen Guardian was saying that. You cannot just put them out, but in ngesindebele sithi mawuhlapes mara sithethe ku-Afrikaans and just yes not look into that
With Afrikaans, yeah.
exactly unfortunate
Blinkers
Yes. Itsho khona ukuthi Indebele is based most on Afrikaans words, yes, yes, but ufaka ama woordlig in, yes, woordlig, yes,
Blinkers, I think, for those of us who are not like you in the chair
yes,
in Afrikaans.
yes. So this was purely that chairperson.
Yes. Yes. Well, and maybe to relate it to a live example, when you were saying that Parliament must look into this, yeah, where you're not avoiding the situation where somebody says something under oath, and has happened even in this committee before, and then correct it again under oath on a later date. Which of the two must you then take as the truth?
You know, I think the main important issue is when you correct yourself, issue a transparency, a fairness, and as well follow the rules which are there, because it's wrong also to just correct something and not even follow the rules or what the practice is, and you do it properly. So I think it's very important to do that. And Parliament, I was showing them this weakness in their system, but anyway, they didn't take it. And they also joined in the court case, which is though well, it's within their right, because if you say the public protector's remedial action is valid unless set aside by a court of law, they are within their right. Again, is that self-correcting process, because it shows as well that as a public protector, I don't have unfettered powers. I'm also subjected to review. So, but my intention was purely to say, here's a weakness in the system, correct it, and it be a better country.
Yes. Okay, I think we can cut through this by simply asking whether your understanding, and I think you've already referred to Mail and Guardian, of your work and your powers and your mandate preclude you when something like this happens. I mean, we all know about it now because it played itself out in the public domain. Are you then precluded from saying this situation that befell the president, how could it be remedied? And in doing so, even go to look into the rules of Parliament as to whether maybe it's not his fault, maybe it's not Mr. Maimana's fault, but maybe it's just a gap in the rules. Now they're saying you should not engage in that because it was not raised in the complaints.
That's it's embarrassing actually to find something like this in the report of the which was led by a judge, former judge Besing Kabinde, and the two advocates, because if you have an inquiring mind, what is the mandate of the public protector? Because we looked into the rules, we even wrote to the speaker, we analyzed the rules, unless we were also wrong. But then when we perused the rules, we found that there's nothing which gives them the opportunity to self-correct or to correct themselves. I mean, again, this was with the intention, Chairperson, to also reduce the number of complaints which are raised under the Executive Members Ethics Act, because there's several ministers who were found wanting based on the fact that they lied in Parliament. So they were never given an opportunity to correct themselves and say, actually, I made a mistake. The true fact is that I wanted to say the following. So that is so wrong of them to say, I should have just focused on the complaint. Because an investigator, you should deal with all the issues where possible. And in this matter, we were trying to also reduce the number of complaints we are receiving where we are being accused, or where I'm being accused that I am factional, I'm political, forgetting that we receive complaints, we investigate, we have the findings, we bring them to the attention of those implicated, and we recommend ways to correct that going forward. So I don't agree with this.
Okay. Now, I want to relate this. I'm now moving to another topic. I think you have dealt with some of the criticisms, but one of the major criticisms relating to the CR17 matter was the alleged or apparent misapplication of the code of ethics. You remember that?
I remember that.
Yes. Now, just to preface that, let's just explain what that's about, because it's in your statement. It's obvious that there are two versions of the code of ethics that was the two versions that were doing the rounds. One was a 2000 version and the other one was a 2007 version, correct?
Correct.
And it looks like there was some massive confusion in various people's minds as to which one was applicable, correct?
Correct. Though, yes, the one would wonder why.
Yes. Okay, well,
You have to give them the benefit of the doubt.
yes, yeah.
You can't be hard on them.
Yes, I think, yes, let's assume everyone it was bona fide confusion and not some, as the chair says, they were not pretending to, to be confused here. Okay. Even if we give that benefit of the doubt, but the essence for the purposes of this inquiry and the topic we're discussing, the essence of that confusion was around the clause that dealt with whether the conduct complained of was willful or whether it would be willful and or inadvertent. We'll come to the actual codes, but you remember that whole debate here.
Yes, I do.
Yes. Now, the trust of the charge against you in relation to this is not so much that you were part of the people that the chair and I are talking about who might have been confused genuinely or otherwise and so on. But actually something much more serious, where the court basically said you, for ulterior purposes, basically rewrote the code to suit your purpose. I think the English expression is cutting the cloth to fit your suit or whatever. But you understand the thrust of this. So it was not like, no, maybe you just picked up as you are getting into your office, just happened to pick up the wrong code and apply it. As you say, it happens all the time. I know many judgments actually where a judge actually applies a law and then it turns out that it was repealed. But you know, it was not done deliberately. So I wanted to comment on that. On firstly, did you go out there, look at the code, think that, no, this code, I won't be able to catch these people with this one. Let me just write my own or remove these words or whatever. Did you do anything that outrageous?
Hey, Chairperson, and SC, that made me, my heart was so sore, or my heart bled when I read those paragraphs, which I think you will be showing here.
Yes, 59, 58.
That I'm blamed duty, I've changed the code. And again, following what we've been doing since I joined the Public Protector Office, we rely on the court judgments, we rely on what the constitutional provisions are saying, the facts before us, again, the very same issue, what happened, what should have happened, the prescripts applicable, whether there's any gap between the two, how can we remedy that? I never changed the code and I was accused wrongfully. You know what is worse is that the very same judge, Pesing Kabinde, we're still coming to the issue in Kandla, was one of the judges who was in she was still the judge of the Constitutional Court by then. They also referred or referenced to the 2007 code, but we're still going to deal with those.
Yes.
Now she comes back and she says or agree to what is being said in the very same judgment of the Constitutional Court.
Of the High Court.
Of the High
Yes.
Court.
No,
Yes,
it's
by
the High
then
Court. Sorry, remember.
it was the High Court.
Just
yes.
for the record, that by the time the charges were drawn, the matter had not yet gone to the Constitutional Court. Yes.
But the fact of the matter is, I mean, she should have remembered Uguti Nkandla judgment was also relying on the very same. I mean, that is a very prominent case. I wouldn't blame her for other maybe cases where you'd find that, I mean, we deal with a number of issues, but that is a very prominent matter. She should have remembered that we are dealing with the life of a person here. Another woman. Can they really say this? Can she really do that? Is she that dumb to change even the code just because she wants to get the president? So I was just regarded as if I'm this evil person who would want to find anything, no matter what.
Yes. And Chair, again, just for the record, because this can be confusing. The two codes, the one is 2000, the other one is 2007. And it was subsequently found that, let's call it the incorrect one is the 2007. So just for perspective as we go along. All right. Now, and the paragraph is in the judgment, Tsepo, the Busasa judgment. Sorry, I've lost the reference, but it should be under judgments with paragraph 60. Paragraph 60. That would be page 355 on my 355. Yeah. Yes. Okay. Chair, can I read it out? It's just a short paragraph. Yeah. Paragraph 60 says this is now the Constitutional Court judgment, the majority judgment. Chair. The public protector's report reveals that on the facts placed before her, she accepted that the president did not willfully mislead Parliament. Well, we'll come to that because that is an issue on its own. Maybe let's just flag it. Did you ever accept that the president did not willfully mislead Parliament?
I don't
Okay.
remember saying that in the report.
Well, in the report, you said that he willfully misled Parliament.
Yes.
Do you
Yes,
remember
I
that?
mean, that's what we found.
Yes.
Yes.
Okay. Let's put that aside. That's not what I'm asking you about now. I just wanted to flag that, yeah. And then it says this meant that he could not have violated the code. The public protector then, this is the crucial part. The public protector then changed the wording of the code to include deliberate and inadvertent misleading so as to match with the facts. That was that attempt at English idiom that I tried with the chair. Having effected the change in the code, the public protector proceeded to conclude that the president had violated the code. It is unacceptable that the public protector did what no law had authorized her to do. So to understand the thrust of the accusation is that you change the code, then you found the president has now breached your code, quote unquote, the one that you have manufactured, and proceeded to conclude that the president has violated that. You've already answered that. You did.
Yeah,
You did
it's
no
not
such.
true. I did no such thing. Yes, in the report, firstly, the finding was the allegation that on the 6th of November 2018, during question session in Parliament, the president deliberately misled the National Assembly is substantiated. It was based on the fact that it was before us. It was what he responded to during the investigation. He was given an opportunity to comment on the findings, and that's not true.
Yes.
And I never, that's why I'm saying how evil I am to just change the code to suit my fact. And I said it last week, Uguti, I don't have anything against the president. I even gave an example, which somebody was even saying, can you truly clarify, are you fighting the president? So things like this, then they perpetuate something like that, and based on wrong facts. Whereas the very same code, the very same constitutional court relied on Nkandla judgment. And also, as a learning institution, we then relied on the Nkandla judgment and our legal framework, because when you go through our report, we indicate what are the common cause issues under that issue we are investigating, what the law is saying about that. So we will refer to the code, we will refer to the Executive Members Ethics Act, we will refer to Section 96 of the Constitution, which deals with issues relating to this matter. Further, we have reports, we call them touchstone, which my predecessors relied, in fact, the reports which they've issued. So there are well-known reports like the prominent reports such as the investigation of the late Mr. Shikega, the Miss Dinah Pule when she was still a minister, Miss Tina Jumat Peterson, and the MEC Yase Northern Cape, Mr. John Block. So the very same 2007 code was used. So now I'm blamed ukuthi mina I've changed the code, which is not true.
Yes. Chair, just to situate this, you'll find in the statement of the public protector at page 629, separate, don't lose that judgment, we'll come back to it. But can you go to the public protector statement at page 629 or typed page 133? The heading, it says the Executive Ethics Code. Specific reference to what?
It's paragraph 294.
294, yes. Right. Okay. Okay, I'll read this out and then you can explain it. It says, the court was therefore wrong to make its findings based on a repealed code. And this is a sensitive issue I intend dealing with extensively during my oral evidence. I've been unfairly and wrongly accused of changing the wording of the code by adding, quote, deliberate and inadvertent misleading of the legislature, unquote, with the intention to, quote, to match the facts, to match with the facts. That's what we read out from paragraph 60. This is the furthest thing from the truth. Evidence will be led to demonstrate beyond any question that my references to the 2007 code were based on the historical reliance by the Office of the Public Protector on that code, long before my assumption of office. In this regard, specific reference will be made to previous reports, including, among others, the well-known Nkandla report, as well as other prominent reports such as the Shitseka, Dinah Pule, Tina Chumat-Peterson, and John Block reports. To this effect, I refer to my rescission application to the Constitutional Court. Same will be uploaded. All right. Now, you've already made a reference to that. Because of time, we won't go to all these Shitseka report, Dinah Pule, Tina Chumat-Peterson, and John Block reports. They'll be supplied for members of the committee to refer to them. But I think just as an illustration, Chair, we'll just pick out the one that the public protector has spoken about, particularly because it also has this dynamic of involving Justice Nkabinde, who was a judge even in that matter. Sepo, can you go to the Nkandla judgment, under those judgments, at paragraph 7? That's EFF versus Speaker of National Assembly. No. I wanted the version that you had the last time, which is from the law report, because it shows the footnote. Is much easier. Sorry. Navigating. Chair, she's navigating. Whatever that means.
Advocate Mpofu, the footnote is there. Footnote 8 on the version we got.
Yeah, I know it's there. All judgments have the same footnotes. I'm just saying the one that she had last week shows it graphically. It's on the same page. Okay, it's fine. Maybe
He's on the same page.
it's not. No, this is that's the softly the version that she had before. Okay, it's fine. Let's not waste time on it. Go to paragraph 8, or rather paragraph 7 on whichever version of the judgment, because it looks like the navigation is not helping us. Yeah, I think, yes, that's the one. Go to the next page. Yes. All right. Okay. Let's zoom. I just saw something else, but
Yeah, I think if you can scroll down,
yeah.
that footnote number 8.
No. We
Oh.
must start where it's no. Go back. Yeah. It says in the same breath, she concluded that the president, she now being Advocate Madonsela, the previous public protector, this is the Nkandla. Yeah. In the same breath, she concluded that the president violated the provisions of the Executive Members Ethics Act and the Executive Ethics Code. And footnote 8 is the Executive Ethics Code. These are the national legislation and the Code of Ethics contemplated in section 96(1) of the Constitution. Yeah. So this is a beautiful paragraph because it covers the entire thing. The constitutional provision, the act, and then the code. And all those things must be read together. Yes. Now let's go to that footnote 8 and see what the Constitutional Court, was talking about. And you'll see that it says chapter 1 of the Ministerial Handbook, a handbook of members of the Executive and Presiding Officers Act, 7 February 2007, at page 7 to 15. In other words, Constitutional Court itself was using the 2007 version for its Nkandla judgment, right?
That's correct.
And have you ever had anybody accusing either Advocate Madonsela or the Constitutional Court of changing the code to suit the facts?
That's why I asked in the beginning why they thought I changed, and then Chairperson said I must give them the benefit of a doubt. So that's what
Don't listen to the Chairperson all the time.
Yes, so that's why I'm trying to say to the committee, the Chairperson, the members of the public out there, honestly, I would say because we worked as a team. These are the reports which were produced before by the very same team of the public protector. And to me, I thought that's the perfect way to go. And they were not impeached. The former public protector finished her term. No one questioned her why she used that code. The current justices of the Constitutional Court and those who've just recently retired, because we made an application for rescission of that, trying to show them that can you correct yourself? But they were not impeached because they failed to self-correct when they are showed that there is this wrong thing which you've done. Because in the Nkandla judgment, you relied on the very same code, but now you're coming back and saying, I invented my own code. I even lodged a complaint with the JSC. Unfortunately, they never wanted to entertain that. And now my credibility is at stake. I'm being labeled this person who is just fighting the president, who's even inventing her own laws just to make the laws to be relevant so that I can find President Cyril Ramaphosa to have violated my code. So it's so painful actually to be subjected to this and sit here and yeah. And I was doing my work the best I know how, with the honesty and credibility, you know, not following up or being behind any other person.
Right. All right. So now I just want to pause with that issue. And again, as I said, the committee and the chair will now give you the benefit of the doubt that in all those other cases that you mentioned, which we don't need to go through now to save time, indeed that code was being applied. When we'll deal with it when we do legal argument. But so what I want to get into again, maybe for the sake of emphasis, and forgive me, Chair, if I'm repeating myself, is that the reason why you're sitting where you're sitting now is not because someone says you took the wrong code by some mistake. Maybe the two codes were sitting on your table and you just happened to pick up the wrong one. The reason is much more serious than that, which is that I think the word you used was invented. Literally, you became the legislature and the judge and the police all by yourself. You wrote a law and then you applied it. And that is what I'd like you to address, not so much whether it was the right code or the wrong code, like the poker and preca thing. It is the fact that you went out there in some dark corner and created a non-existent law.
That's not correct, because that's very, very wrong. I never did that. I think there was when Mr. Matebogo was testifying, I think one of the drafts had the 2000 code. And I think there was an email which was shown here that I said to Mr. Matebogo, use the 2007 code. And it was purely based on the fact that the Concord judgment is based on that code, the touchstone cases, and this institution, practice-wise, we've been using that. And they will then say, I just within my own evil or sinister intentions, I just pick up this code and say, no, the facts of the matter, or the way the facts are, then let's apply this code. I was honestly applying the code based on the fact that it has been the practice of the institution that this is the code which is utilized. And no one was said to be held to be incompetent or misconducted themselves because they had findings against the sitting president.
Yes. All right. Now, maybe let's do this then. As I was saying, let's park that issue and let's take the committee then to the correct code. We now know that everyone had been using the 2007 code, including the Constitutional Court and your predecessor. But at the beginning of the judgment, if you can go back to that judgment, the CR 17 judgment, the majority then quotes or cites the correct code. And that will be page 334, Tsepo. right at the, yes, if we can go to the, yeah, there. Talks about the Executive Ethics Code and footnote 2. Can you go to footnote 2? Right. Okay. Now, so Chair, you'll see there that that code that refers to the correct code, as it were, which is the code of 28th July 2000. Right.
Mm.
Now let's
Correct.
look at that code for now. Indeed, it says that this is what it provides. Members of the executive must, to the satisfaction of the president or premier, as the case may be, A, perform their duties and exercise their powers diligently and honestly. In fact, Chair, maybe let me explain why I'm doing this. The suggestion in the majority judgment was that the code is narrow, must be read narrowly. And our version, when we argue the case, will be that it's actually a wide ranging code by definition. Forget about whether there's advertent and so on. But just by its nature, it's meant to cover a wide range. By the way, it's a code of ethics. And ethics it's not a code of law, as it were. Yeah. So that's where I'm going with this. Yeah.
Okay.
All right. Now, sorry.
Just pause, Advocate Mpofu.
Advocate Mpofu, are we now going into an argument on law? Because I thought you said this morning we were not going to be arguing the law.
No.
I just
no.
want to understand.
No. I think you misunderstood me. I'm not. That's exactly what I'm not doing. I'm saying I'm just. We'll argue all this, you and I, at the end. I'm simply just for the members to know why I'm referring to this code from the witness. Remember, we're testing the witness's understanding of these things because she's the one who's the police who applies the code. So I'm not getting into the legal argument. It's a fact that there's a 2000 code. It's a fact that there's an alleged 2007 code. And I'm just going into what it actually says. I'm not putting any slant on it here.
Thank you.
Can I just maybe get the ambit of it? Because we also had agreed certain ground rules that the report is what the report is, and it's the report that would be essentially considered here on a factual basis we're putting in. So I'm just checking where you're going now, where it fits into the report. If you could maybe just clear that up.
I think that's a fair question, Chair. The point I'm making, and I think I know where my learned friend is going. The simple point I'm making, and that's why I was making that editorial to the Chair, is simply whether, against what I'm going to read, whether it is correct to read the code as a narrow document or it was intended to be a wide document in the understanding of the public protector. Remember, again, this is not just a witness. This is the public protector, the person identified in law to police these codes and all these things, among other things. She says she wishes it was Parliament who primary has a duty to police, and then it's referred to her. But as we sit now, that's not the case. It gets referred to her directly, as was done by Mr. Mkhwebane and Mr. Shibambu and the others.
Okay.
Thanks, Chair.
Thank you. We'll proceed.
Okay.
Just switch it on back, Advocate Mkhwebane. Thank you. Over to you, Advocate Mpofu.
Okay. I'm not going to waste time on this PP because that's not the question is going to follow. The code says members of the executive must, to the satisfaction of the president or premier, as the case may be, A, perform their duties and exercise their powers diligently and honestly.
Correct.
Okay. And maybe the question I'll be asking you, the refrain, is whether do you view that as a wide power or a narrow power?
That is a wide power. It's not narrow at all.
Yes. And then it says those members must fulfill all the obligations imposed by them by the Constitution and the law. Wide or narrow?
It's also wide.
Okay. They must also act in good faith and in the best interest of good governance. Wide or narrow?
It's very wide.
They must act in all respects in a manner that is consistent with the integrity of their office or the government. Wide, narrow?
That is wide and very important for our investigations.
Yes. And then if you just go to the following page, Tsapo, continuing with that footnote. It's now footnote 3, yeah. Yeah, okay, right there, yeah. Okay, let's jump the first one to A. Well, we know that this applies to members of the cabinet, which include the deputy president. So B, it says the code must include provisions prohibiting cabinet members and deputy ministers and MCs from undertaking any other paid work. You know that comes almost directly from section 96 of the Constitution. Correct?
Yes, correct.
Acting in a way that is inconsistent with their office, wide or narrow?
It's wide.
Exposing themselves to any situation involving the risk of a conflict between their official responsibility and their private interests.
It's
Wide?
very much wide because it doesn't say there must be a conflict. It says you must not expose yourself to that conflict. It's wide.
Using their position or any information entrusted to them to enrich themselves or improperly benefit any other person.
Is wide.
And acting in a way that may compromise the credibility or integrity of their office or the government.
It's also very wide.
Yes. Now, and this is really something, sorry.
Advocate Mkhwebane, the first section you read was 2.1 of the code. The second part is 2.2 of the Act.
Yes.
I just wanted to understand that we're not interpreting the same thing, because I don't understand Advocate Mkhwebane to have said that she has powers under the Act. She has powers under the code. But that was your evidence last week. So that's where I'm getting a bit confused here.
Thank you, Chair. I think now this is a matter for legal argument. We have said earlier that's why I said that was a beautiful paragraph in the judgment, because it overcomes the problem that you are raising. Because in the same breath, it refers to section 96 of the Constitution, to the Act, and to the code as one system, and that's really what I'm doing. So I'm sorry if I didn't specify that. I'm now referring to the Act. But as far as I'm concerned, yeah, 96(1), B and C in particular, the Act, section 2, and the code really speak to the same ecosystem, for lack of a better word.
Thank you.
Thank you, Chair.
Proceed. We're clarified.
Yes, thank you, Chair. Sorry, I forgot now what I was saying. I was saying that put aside this thing about inadvertent and what have you. Yeah. What is your responsibility as public protector, as I put it, quote unquote, the policeman or policewoman of the executive ethics code? How do you understand that job in view of these instruments that we have just gone through?
I think it's what you've also indicated that or clarified, Advocate Bauer, that from section 96 of the Constitution to then this legislation, the Executive Members Ethics Act, which is called EMIA, and the EMIA refers to the Executive Members Ethics Code. So it's like the code is like a policy kind of, reference. So the public protector, I said last time, is the only one of the few institutions in the world, not only in South Africa or in Africa, in the world, in the ombudsmanship institutions, which investigates the executive. And this act is very clear that on receipt of a complaint by the public protector, we must investigate and finalize the investigation within 30 days. So the investigation of the public protector, when we deal with the report and we deal with the legal framework, we will mention Section 96, we will mention the Act, we will mention the code. So if things are just blown out of proportion as if we only then focused on the code, but the fact of the matter is, what is the Constitution, which is the supreme law, saying about that particular conduct? So if you are truly interpreting and applying the law, surely we should be checking the conduct of that public official against the code. So the code is giving effect to section 2 of the Executive Members Ethics Act. And I think SC and Chairperson, I said, and members of the committee, I said every year during my road shows, I would also then meet specifically with the members of the executive. Fortunately, in the provinces, I met with them several times, where with the 5th administration, I took them through the code, the Constitution, the code, the Executive Members Ethics Act, and what the code is saying. And then also through the 6th administration, the provinces, the same was done. Unfortunately, with the national ministers, that was the opportunity never presented itself, but we requested the speaker as the Forum for Institutions Supporting Democracy to say we needed to take the executive through our mandates, Public Protector, Gender Commission, Human Rights Commission, so that they know what are their responsibilities. More specifically as well, because of the oath of office which they take as members of the executive, to abide by the Constitution. Therefore, you cannot be a minister of health or of education and just do your work and forget what are your constitutional responsibilities. So hence, throughout the process, we used all these three, and they are similar actually, because we would say the ethics code contemplated by EMIA was published by the President 28 July 2000 and amended on the 7th of February 2007, because that's what one was under the impression that this is what happened. And indeed, both the code deals with the issue of how members of the executive should conduct themselves, perform their duties and exercise their powers diligently and honestly, still the same thing, and fulfill all the obligations imposed by the oath. So that's what the code has been saying.
Yes, and before we take the break, I think so that Advocate Bauer can also chew on it. And is the statement that Advocate Bauer makes correct, that your role is to, and this is my word, not hers, police the code of ethics and not the act? In other words, not a mayor.
No, not true.
Okay.
I mean, how do you reason like that? As I said, that the Constitution as a constitutional institution and the Section 182 of the Constitution is very clear. The public protector shall investigate any improper conduct in state affairs, the way it's crafted. So then any improper conduct is a constitutional mandate. Therefore, it flows down to then any conduct or which is improper flowing from the Constitution to the legislation to the policy or regulations It's the responsibility of the public protector. Again, going back to say, our model of operation or investigation, we always make sure that whatever conduct, is it according to or is it compliant to any legislative framework? Hence, if we investigate a simple matter, which normally I would do when I do AMA road shows, to bring it to a level of saying to the public servant or to an executive or the municipal manager, you advertise a position, you say the requirements is 5 years experience with a degree. You appoint a person who has a matric with 2 years experience. That's which I'm trying to simplify the work, what we do as the public protector to any person, to a judge, to any person, member of parliament. Then if we find, and when we investigate, we will then write to you as the executive, as the municipal manager. You advertise, give us the advert. There's a complaint from Busisiwe. You've appointed Simpofu, and then you say in your advert 5 years experience plus degree. Mpofu has a matric plus 2 years experience. In all our investigation, that's a simple basic thing. Give us the advert. Give us the people who applied. Give us the committee which said to determine you are appointing advocate Mpofu. Then the reasons, same applies to tender processes. That's what we do. Give us your own internal policy, because that's what the AG also does. What is your policy saying? Can you really advertise and appoint contrary to what you are saying? Then when we have a finding, we would say, indeed, you acted contrary to your policy. So similar applies to this, because we will take it from the section 195 of the Constitution to the legislation relating to your operations, to your internal policy. So similar applies to this one.
Good.
The Constitution, the Act, and what the Executive Members Ethics Code is saying.
Chair, just one
Okay.
bite.
I didn't want to spoil that so that we can digest that.
Yes.
But
Yeah.
please
Yeah.
conclude.
Yeah, no, this is important. I think just around so that we don't come back to this. And the example that I'm going to use is something that we're going to cross-reference in relation to your suspension and so on. But I'm asking now in a different context. Let's use the example of the Phala findings. So you are the public protector. You had your own process, 31 questions, what have you. And that's against an EMEA complaint, correct?
That is correct.
Yes. Somewhere else, there was another process led by Chief Justice Ngobo. He was not applying, he's not the public protector. And made findings about the prima facie evidence on criminal conduct, the breach of PRECA, and so on and so on. But the point I'm coming to is this. Your process and his process were using the same source documents. So the Constitution, Section 96, was it breached, yes or no? The EMEA, which binds on the president, and his obligations to Parliament, if any, and so on. So maybe that's what you can explain before we take the short break, as to why these three things in both of those exercises work as a unit. You can't separate the code from the Act from the Constitution in respect, for example, of the so-called risk of conflict.
I think the Constitution, which is the supreme law, as I said originally, and I think that's what the panel found, that the breach and the violation, because the Constitution is very clear, Section 96, you don't have to prove issue here, violation of or conflict. They say a risk of a conflict. So in other words, you should conduct yourself in such a way that you are beyond reproach and you don't expose yourself to that conflict, you don't conduct any paid work, you don't avail state information which is under your care, because some of the complaints relate to that, to benefit yourself, you act in good faith and to the best interest of good governance. So, you know, those issues are connected and interlinked. Therefore, you cannot have a situation where, because on the face of it, if you have former Chief Justice Ngobo finding that there was that prima facie case, and there is evidence before the public protector that there is the allegations that there was monies which were found, and I mean the president saying it himself, there's recordings acknowledging and agreeing that indeed it's trading. But then I think again, the question is in foreign currency, is it a legal tender in South Africa? Are you justified to say that? But as a public protector, we will then focus on the mandate of the public protector as far as Executive Members Ethics Act is concerned. Then the other issues relating to whether there was any failing to report, PRECA and whatever, and whether that is it a crime, we refer it to the relevant institutions like your NPA, like your the Hawks. We wouldn't say you are guilty, because that's not what the public protector does. We just do that purely on the evidence before us. But again, going back to how the issue of beyond reproach, I didn't want to mention the issue, because lest I be accused that, yeah, you see, she's a politician. The ANC will say, went through the eye of a needle. I would normally say that to the various executives in the provinces, that if you say that, you mean you are this angel. But yes, you are human beings. You can falter sometimes, but try your level best to act according to what the Constitution, EMIA, and the Executive Members Ethics Code is saying. Because when you enter into this position, you want to be the servant. It means you are not entering to be benefiting yourself in whatever you are doing.
Yes, I think that's a good note to end the chair, that through the eye of the needle. Well, that's the test, and we can deal with it later.
Okay, thank you. On that point, thank you, colleagues. We'll take 45 minutes lunch and be back after 45 minutes. We pause for lunch.
Recording stopped.
I'm just going to try and kill two birds with one stone. The section that we were dealing with is page 629, Executive Ethics Code. And in your statement, the next section refers to violations of section 96(1) of the Constitution. You see that? That starts from page 298.
Well, paragraph
298.
okay. Yes.
Yes. And then there's the next section is on Audi. So we're now, I think, with the answer that you gave to the discussion we had with Advocate Bauer, we can condense the ethics code and then section 96(1) into one thing. But
maybe let me just indicate that the Executive Members Ethics Act, section 3, subsection 3.
yes, that's where I'm going.
Okay.
No, but you can, to save time while we're going to call it up, but you can, Emir, as Advocate Bauer will assist me to under bundle of the legislation. Bundle C1, yeah.
Which,
okay, you can talk in the meantime, PP, so it will come up, yeah. This is now on the connection between the code, the Constitution, and the EMEA. Yeah.
yes. Then the act will then say the public protector will investigate the matter. Well, section 3, subsection 3 refers to when the public protector fails or cannot finalize the investigation within 30 days. Then the public protector will refer the matter
Right.
to, yes.
Okay, so sorry.
Yeah.
Okay, Chair, this is quite important. This is really the heart of at least this case we're dealing with, and the next one, which is the rogue unit. But also we've been talking since we started about this thing of the 30 days and what have you. And so this shows where it actually comes from. Yeah.
Yes.
And maybe.
So in other words, the act is the one which then gives the public protector the powers to investigate the breaches and to investigate the complaint and submit a report to the within 30 days of receipt of the complaint to the president if it's relating to against the cabinet member, a premier or deputy minister, and to the premier of the province concerned if the complaint is against the MEC. So then if we cannot finalize the investigation within 30 days, then the public protector must submit a report. In fact, the first one, it says we must submit a report referred to in subsection 2. So that means the preliminaries, and the second part of subsection 3, it says, then if we haven't completed the investigation, we can then inform the president or the premier if it's about the MEC.
Yes, thank you. All right. So this really is the core of your investigating powers as far as the executive is concerned, of course.
Correct.
We're not talking about other branches of the state. Now, this seems to then be the source of what some might call your enormous powers. And how and you've said that it's in terms of other jurisdictions, it's unique to us as South Africans. And I think Honorable Sokoni warned us, for lack of a better word, about the more drastic the powers, the more like Newton said, yeah, for every force there's a opposite and equal reaction, as it were. I think that's Newton law number 4, Chair. It's a long time since I studied physics, but yeah, but you know what I mean. So can you just comment on, firstly, you've already said that you wish that it would start in Parliament and so on, but on the enormity of that power, of you being the first port of call, where the legislation basically by name says the public protector must investigate any alleged breach of the code of ethics on receipt of a complaint contemplated in section 4.
Yes, yes, the powers which are granted to the public protector in terms of the Executive Members Ethics Act are so actually vast, and in other ways, it's even worse because it doesn't give the public protector a discretion. Remember, the Public Protector Act under section 6, subsection 9 will say the public protector will use her discretion whether to investigate or not to investigate, the one we will deal with when we deal with the SARS matter and the others. But then here it says the public protector must investigate. I don't have that discretion to say, no, you've brought the complaint, therefore I cannot investigate. So remember in the first, well, when we were dealing with the opening statement and part A, in fact, this
landscape.
This statement, yes, I think the chairperson was saying the landscaping, but then I also dealt with the issue of touching the untouchables. And again, it goes back to Chief Justice Mkhwebane judgment in the Nkandla, where he says the public protector is investigating the most powerful, well-resourced, deep state, and unfortunately, they wouldn't want to be held to account. So the powers in this Executive Members Ethics Act are so vast and so broad, and especially if you investigate the president of the country, the ministers, people who have the power in society, people who have all the resources which they have. And if they would honestly be genuine enough and understand that this institution is there, and by the forefathers of our constitution, going back to our President Nelson Mandela, going back to the institution of being an ombudsman, because if you have a king in Sweden thinking that I have all the powers, I can instruct any person to go and kill any person or to go and do anything they would want to do. But then I would want to have an ombudsman who will be the mediator between the citizens and the most powerful. So if you investigate the president and you hold the president to account, definitely you will then face such, well, that's why I'm sitting here. And whereas you find the media, which is also not helping because it's a key strategic partner of the public protector, which in any democracy, they should be the ones who are the voice and who are also helping to address issues of corruption, issues of maladministration. But then you find that they are the ones who are then magnifying the mistakes which we do, and mistakes which are trying to show that the facts before us and the evidence is the violation of this particular legislation or of the constitution. So the similar thing which happened is that with this investigation of Busasa, I'm sitting here is part of the charges in this hearing. Because of what I investigated. So I'm facing the consequences or the wrath of what Chief Justice Mkhwebane said. Now, with the issue of the Palapal, sending those 31 questions led me to be suspended a day before even the court was supposed to pronounce on the judgment. But at the end of the day is that these are the repercussions of investigating the powerful. The That's why that arm of the state, which is the executive, is at the core of my challenges as the public protector. My predecessor faced the similar issues, but it was better with her because she never reached a stage where she's sitting here and being subjected to impeachment. Because, I mean, you know, you also tried to show her that the very same, some members who are here, they were calling you names, they were vilifying you, they labeled you a spy and all those. It's because we investigate the most powerful, the owners of media industries and capital who don't want to account. And as a country, we're dealing with corruption because there's a corrupter and a corruptee. And who corrupts and who create all the challenges is those who have the resources and the means to have the resources. Unfortunately, with me is that then you find we'll still deal with it. Then there another arm where I'm taken to court and there are judgments which are issued, like what we dealt with now, the code and the very same issue of the CR17, where the facts are not correct. The facts are wrong and the judgment is out there. Just because it's a judgment, yes, we respect the judiciary, yes, the outcome, but the fact of the matter is now this process, that's why I said, I'm so happy to sit here, take the public, because at least they would also want to know exactly why are you being persecuted, or, you know, you label this person who doesn't know the law. But I'm just now with this Busasa issue. Here's evidence before court. This is what we considered. We came to a conclusion that there's a violation of this law, the Executive Members Ethics Act, the Constitution. And that's all what we did. So I think those are the main causes of me sitting here and now being on suspension because of Phala Phala and the 31 questions.
Yes. And I think that, yes, thank you very much for that answer. In other words, forget, you can change the players and the public protector and the president and this and the other. But given the powers that are bestowed on that office, is there any difference really between what you are going through, as you say, and what happened in the Nkandla business? And I'm saying that in relation to, we know the obvious similarities. Both matters involved the trilogy that we spoke about, EMEA, the code, and the Section 96. Both were against president of the country. Both were adverse findings against such a president. And incidentally, both relied wrongly on the wrong code to some extent. Yeah. But that's just by the way. But if we forget about the personalities involved and look at those cases, the Nkandla experience, where and what your predecessor went through, and your experience with Busasa, CR17, and to some extent Phala Phala, as you mentioned, forget whatever happens to you as an individual. What learnings should the country take from this? Because it's either things are getting worse, and remember that in a way, Ms. Matotsela got away at the right time, 2017, just the year after the Nkandla case that said the powers are binding. And you went in right on the face of the storm and had your 7 years in that era. And come the end of this year, we'll have a new public protector. And we don't want a trend where that person will be flattened out in a few months, as it were. In other words, we don't want the situation to get worse, we want it to get better. What apart from your quote unquote amendment of EMIR that you've referred to, where there'll be a filter through Parliament, what else can be done to ensure that the powers are tempered or in such a way, or that the public protector is protected? Because it's one of the two. It's either you're going to temper the powers, as Honorable Sokoni was suggesting, or provide more serious protections, or both.
I think for me, again, going back to the issue of saying the Constitution, the way it's crafted and it's providing for this institution, and that this institution should operate independently without fear or favor. And the issue of fear or favor and the independence is affected by a number of things. I mean, how the institution is being funded, it's a challenge how the institution would find that the resources are being, they are not provided enough resources to do the work. And this institution, the powers which this institution has, there's nothing wrong with. As long as you have political will, as long as you have people who are in the executive who would understand that they are there to serve, not they are there because they want to, or it's just creating their own kind of fiefdom, or, you know, I'm in this position, I've got this power. But then how do you maximize and use this institution to your benefit? Because I think that's one thing where if you are a minister, and I've said it last time, you have challenges in this part of your department, for instance, health, hospitals, the way they operate, or water and sanitation, or this issue of pit toilets, if you are education. There's nothing wrong you approaching the public protector. And that's what when I was training, or we were going around the provinces, even informing the members of the executive that, you know, the late Gada Asmal did that during, I think it was Mushwana or Bakwa's time, where he approached the public protector and said, public protector, can you investigate the issue of communication in the public service? Communication in the sense that how does the issue of red tapes affect service delivery? And there's that report like that, because that person understood that this institution is so valuable, is a constitutional gift to the public. And if you are an executive, you want to serve the public, you would do that. Secondly, you then also have to work with all your NGOs, the ones who are calling themselves to be, you know, NGOs looking after the issues of the poor, the marginalized, the human rights violations, service delivery issues, should be partnering with this institution, irrespective of who is then incumbent. Because unfortunately in South Africa, once the media or those who don't want you, those you've investigated and you have findings against, in Chinese, they say a person lose face, meaning because you kind of, they think you've embarrassed them, but that's not the intention. You are having this responsibility, you issue the report, and as a person, you should learn what must I learn from this particular process? So I think if my successor can be treated with that respect, because unfortunately, I feel as if this institution is being, its powers is being weakened, and this confusion as well, unfortunately, in the Constitution, where you'd find Section 194, the committee determining the fitness to hold office. Then again, it goes back to the president, who will have to suspend the very same person, and the very same person is investigating the president. So there's that a challenge and quagmire or issue with that. But then even if it's there and we dealing with the institution, we don't check who's the incumbent and what can we maximize from this institution, then we wouldn't have challenges. But that's why I'm saying possibly my successor will be favored by the those who have power or the media, because I think the media plays a very critical role in this instance.
Thank you. Advocate Mpofu.
Thank you, Chair.
I mean, whilst you're still looking, even the issue of the judges, since the judges are there to adjudicate and interpret the law, I think our expectation or my expectation is that if you review a matter, but then I think you can correct me, the chairperson, an appeal is different to a review. And a review most of the time is you can review the matter and send it back to the decision maker. But then there was then an attitude most of the time, I think it started with the free matter or we'll deal with it. But in the pleadings where then they will say even that mustn't be returned back to the decision maker, because the main aim was to, when you review, you'd say, public protector, you didn't follow process here, you didn't do the following, go back and do it proper. And because as a court, you are focusing on the poor, the people who don't have the means, the people who can't approach you as the court, and the court, you are there to be blind, to make sure that there's justice. So it's purely that. I think they've got a huge role to play as well, to understand that this institution is not like a police. Yes, it has those powers, but those powers are unfettered because they can be taken on review.
You have covered, I think you have given him enough time now to get back to the issue. So let's go back, Advocate Mpofu.
Yes.
Thank you very much, Chair. Yes, and Chair, I know we've read this out before, but I want to reread it in the current context. This is the famous statement which you find at paragraph 52 of the Nkandla matter. Well, Chair Paul, while you're finding it, paragraph 52. I think that I'll just read it out because everyone knows about it. Yeah. So at the middle of 52, says the tentacles of poverty run far, wide, and deep in our nation. Litigation is prohibitively expensive and therefore not easily exercisable. Rather, not an easily exercisable constitutional option for an average citizen. For this reason, the fathers and mothers of our constitution conceived of a way to give even to the poor and marginalized a voice and teeth that would bite corruption and abuse excruciatingly. And that is the public protector. She is the embodiment of a biblical David that the public is, who fights the most powerful and very well resourced Goliath, that impropriety and corruption by government officials are. The public protector is one of the true crusaders and champions of anti-corruption and clean governance. And then the first sentence of the next paragraph, hers are indeed very wide, not just wide, very wide powers that leave no lever of government power above scrutiny, coincidental embarrassment, and censure. And then if we can just jump to paragraph 55. And this is where we talk about the protections here. Her investigative powers are not supposed to bow down to anybody, not even at the door of the highest chambers of raw state power. The predicament, though, is that mere allegations and investigation of improper or corrupt conduct against all, especially powerful public office bearers, are generally bound to attract a very unfriendly response. An unfavorable finding of unethical or corrupt conduct coupled with remedial action will probably be strongly resisted in an attempt to repair or soften the inescapable reputational damage. It is unlikely that unpleasant findings and a biting remedial action would be readily welcomed by those investigated. Comment?
Maybe just before comment, if you can assist Advocate Mpofu, you had made the point yourself.
Yes, Chair.
We did cover this
We did.
ground,
Mm.
so that I don't want us to
To revisit.
repeat
Yes.
and
Yeah.
go
No,
back.
fine. No, fair enough, Chair.
We
I'm
covered
just,
it
I don't want
quite
us to go to
extensively.
town on it. Yes, I
Just
just want in the
really
context of what we're discussing,
Okay.
the powers, the EMEA powers and so on. To only confine it to that public protector.
Thank you.
The Chair is right.
I didn't get that. It relates to what?
No, remember what we're discussing is the extensive powers from EMEA, the likely reaction, and so on. So I'm saying, I'm reading this in that context.
Okay.
Remember, we dealt with this in the landscaping, just in terms of the general powers of the public protector. Yeah. So I think the Chair is saying, let's discuss it in the context of this Newton's law that I was talking about.
Okay. Yes, definitely. I think you are confirming what I said earlier about the raw state power in the losing phase, because those are the powers of the public protector, and people do not want to be held to account.
Mm.
And once we issue a report, it's like it's portrayed as if one is fighting that president or that minister or that MEC. And of which is not the case. But the fact of the matter is that a complaint has been lodged. We have the power to investigate. It's a must. It's not a discretion to do that. And I think this paragraph, Chairperson, is very critical, because when we deal with the alleged rogue unit or SARS matter, the issue of raw state power and where one is regarded, or where you are told you can't get this or you can't have this particular information, and you are just tossed up and down. But we have a constitution which gives you all these powers here.
Thanks. And maybe, to focus it, as I said, the Chair,
To this,
so that we don't go back to the landscaping as such.
Mm.
I'd like us, maybe let's use the one case study that you just mentioned now, which if we go to BM10, Annexure BM10 to the Public Protector Statement, that's the case that you just mentioned, which will clarify both the EMEA, the broader EMEA point. That's your investigation into the Pala thing. And I'm more interested just in your introductory remarks. BM10. You've already testified about your view that this was the cause of all your problems and all that.
Yes, it's what paragraph in my affidavit?
It's BM10, sorry.
Chair,
Yes, Advocate Brown.
I understand what Advocate Mpofu is seeking to do, but the letter is generated post the complaint and post the issue of that. So we're now going to events which happens post what this committee seized with, which I thought we had agreed was not going to happen.
No. Okay.
Yes, Advocate Mpofu.
Thank you. Chair, no. I'm not doing anything of the sort. I'm saying we're using this, which is why it's here, to illustrate. It's relevant for two reasons. One is illustrates what we're discussing now, which is what an EMEA investigation entails, but also, in fact, this is prompted by the question from the public protector, which I think is more helpful. It relates to the body of the statement where this is attached, and that you will find, Chair, at paragraph 48 of the statement.
Paragraph 48.
Yes, page 517. So it's, as I say, almost killing two birds with one stone. It discusses what we do now, but also dispenses of that portion of the affidavit. BM 10 is more see, she goes, I'm not dealing with the previous stuff. We've dealt with that on 1st of June. There was a complaint from Arthur Fraser and so on.
I think it deals with the suspension.
Yeah, and then deals with the suspension, and then on the
Just a pause. Advocate Bauer.
Chair, I don't want to interrupt, and I haven't been interrupting, but I understand from this that the first probably 49 paragraphs of the affidavit, besides the qualifications, are all background. We had raised, Advocate Mpofu dealt with the suspension many months ago, where I thought we had reached an accord that this committee has no powers in respect of the suspension, nor is the suspension linked to the motion. And you had raised a number of the factors in addressing this committee, both in your opening address, first one and the second one, dealing with the question of the suspension. I'm not sure if we're going back there now.
Chair.
Yes.
Thank you, Chair. No, we're not going back to anything. Well, first, maybe let me ask the witness. Advocate Mkhwebane, can you explain, or rather, do you subscribe to the theory that the suspension is not relevant to what we're going through here in this inquiry?
Thank you, Chairperson. I was going to just indicate that indeed it's in my statement, and I would like to put my side of the story to this particular matter, because for me, the issue of the suspension is directly linked to the operations of this committee. So indeed, there's no way I wouldn't deal with this, because that is provided for in terms of section 194. Exactly what the section 194 is saying. There would be a committee to determine this, and after the start of the proceedings, the president may suspend. And with me, the president even suspended even before the start of that particular committee. So I don't, for me, I hear what is being discussed, but for me, I would want, because that's why I am suspended, because of this investigation. It links up, Chairperson, to my powers. Investigating the most powerful under the very same legislation. Section 96 is linked to the Executive Members Ethics Act and the Code. And that letter was sent, I've indicated in court, but here I also indicated when I served the letter and when I was suspended. So for me, it's at the center and at the center of these proceedings, and for the public to also know that why I am raising this matter, because, and why the suspension. Definitely, according to me, you can't separate the suspension from the from this process.
It's just two things so that we proceed properly. The first one, you just need to indicate where we are now, because the last time I checked, we're at 298. The violation of section 96, and then proceeding in that way, but I don't want us to be all over the place. So that we walk with you,
Yes.
In terms of this. That's the first point.
Thank you.
The second point, I think this comment is not going to lock you out in terms of what you want to say or not to say, but we're a committee that has a mandate, and we operate within that mandate, and we're in a legislative space. because whatever that we do now, and what we'll conclude on has got to be focused on those kind of issues. We would not want to encroach any executive space in terms of what we do. I think as a chair, I've been communicating that consistently, but it doesn't prohibit you expressing yourself on those matters. That I would allow, but as long as you know, as you do that, you can't create expectations on us on that we cannot fulfill and deal with.
Yeah. Thank you, Chair. And for your comfort, Chair, thank you. I appreciate that. I promise you, we will not, this is not the place where we want to complain about the fairness or unfairness of the suspension or whatever, because that would really be now putting you in a space that you don't belong to. The sole purpose of this is, as I say, literally to kill two birds with one stone, is to show a typical EMEA approach, which is what we're discussing, but also to deal with what, and I accept what my learned friend says about their view of the connection. But our view of the connection is that, as explained by the public protector, that both processes emanate from 194. And in fact, the so-called suspension is a suspension pending this process. So they are symbiotically linked. But I don't want to get into that debate right now. I'm simply saying that this is something that is in the statement. This is an attachment to the statement. It's not something we're importing. It's already before the committee. And I just want, actually, we would have been done with this because I just wanted to show the flow of receiving the complaint from Mr. Zungula, and then you do this, and then you do this, then you do this. And it's really in that context as a typical EMEA complaint. Yeah, okay.
And you are using the Balabala thing as an example,
Yes,
because it would not be a subject of
absolutely. That's why I said case study. Yeah.
Okay.
Thank you, Chair. All right, can go to BM10. I'll go even faster, so because we've just wasted time on this. Okay, BM10, and that's BM stands for Busisiwe Mkhwebane. That's the an annexure to your statement. All right, I'll just do the highlights. Go down paragraphs 1 and 2. So in this example, you have an EMEA executive violation, investigation to allegations of a violation of the executive's code against the President of the Republic, His Excellency, Mr. Ramaphosa. And then you say that, I'm going to paraphrase, on the 3rd of June, you received from Mr. Zungula a complaint, correct?
Correct.
And then in paragraph 2, you then say that what Mr. Zungula alleges in essence, that you concealed a crime from the South African police services and so on. You paraphrase the essence of the allegation, correct?
Correct.
And then at paragraph 3, you then talk about the filing of the complaint at the police station by a Mr. Fraser, correct?
That's correct.
Right. All right. Then, so that's the first section. The next section of the document then details what Advocate Bauer and I have been debating, which is the connection between EMEA and the code, right?
Mm.
Then, and then the PPA, the Public Protector Act.
Yes.
So you refer to Section 7.1 of the Public Protector Act. You refer to your powers in terms of 182 of the Constitution.
Mm.
Then Section 3 of EMEA, the one that you read out to the committee just now.
Mm.
And then you, sorry, Chair. 3 pages later, sorry, I don't have, what's the page at the top, Tsepo? 699. Okay. So let's go to 700. there you talk about that the evidence furnished by Mr. Fraser also made it practical to entertain the matter and the seriousness of the allegations involved money laundering, tax evasion, kidnapping, defeating the ends of justice, and so on. And then the important part for the purposes of this discussion is paragraph 13, where you then link all that up to section 96 of the Constitution. Okay, so that's the tripartite connection that we've been making since just before lunch.
Yes.
That this type of investigation would then anchor in the Constitution, refer to a mayor,
And
then
the code.
apply the code here. Okay. And you then say at paragraph 15, all right, you've already read section 3 of EMEA. Right, and then in the spirit of, well, I see Honorable Sukas is not here. After that whole fiasco about which code and all that, obviously you've now taken your lesson from the judgments and you go to page, sorry, 702. Just jump 701. Yeah. Right. And there you cite the code.
Yes.
Obviously now this is the correct code.
The 2002, the 2000 code, because
yes,
yes, we've learned now
from all these
the
judgments.
Concord, yeah.
Yes.
They've changed also now, they've relied on the 2000.
Yes. And if Chair, if you allow me, please, to kill the third bird with the same stone. While we are there, can you quickly, okay, I've lost the reference. There's the 2007 code, we just posted it.
Okay, yes, to compare the two.
Yes, so
The
while we're
changing
here,
of
so
the
that
word.
we don't have to go back to that, yeah.
Okay.
Just a pause. I see the hand of Honorable Sukas.
Yes, Chair, I just want to tell the Honorable Advocate that I am actually here on the platform. Thank you.
Yeah, no, I'm aware he was referring to you being physically here. So
Yeah.
we know that you are in the platform. Thank you.
Thank you, Honorable Sukas.
Wanted to look at you, so you
Yes,
can't look at you.
I
in
was
the virtual.
looking, thinking that I was going to catch your eye. Item? Sorry. Okay, it's bundle H, the PP folder, item 31.7.14. And again, while we're looking at it, just for the benefit of the members, this relates to the.
Please mute Seppo. Don't know what's happening there. Advocate Mbofu.
Thank you, Chair. This relates to the topic about the confusion that the Chair and I were referring to, whether it's bona fide or not bona fide, the confusion between the 2000 and the 2007 code here. I just wanted to get rid of that for the sake of completion by just showing the members where this thing about advertently came from. That was said to be invented by the public protector. And in fact, at the appropriate time, Chair, I'll demonstrate that in the Nkandla report now, not the judgment, in the report itself, there's a reference to the inadvertently and all that. Okay. Are you there, Tsapa?
Okay, IT up there. Do you know what's happening? We're not looking for a clip. We're looking to show a document. So let's assist us there.
I think it's IT, I think it's section 3 when you find it. or paragraph 3. 2.3. Yeah. It's actually highlighted.
You sorted, Seb? Okay.
Okay, there's a technical problem. All right, we'll check and I go on. We'll come back to it.
Okay. Okay. Thank you.
Thanks. All right. In any event, you've confirmed that is a citation of the 2000 version of the let's call it the correct version. Correct, PP?
Yes, that's correct. In the now this new investigation to show that we are learning, we move with the time.
Yes. Or to show that, yeah, this time you did not invent
I never
the word,
invented.
the word advertently. All right.
It's the number 2 now about
Yeah.
IT. Are you having challenges? Okay. Thank you.
Oh, there you are. Chair, forgive us for the underlining. It's ours just for emphasis. So that version then of the quote unquote wrong code, which and the point here is whether it was a mistake of applying the wrong code or inventing a new word here. It says, yeah, members may not deliberately or inadvertently mislead the president or the premier, as the case may be, or as the case may be the legislature. Then the rest is what we read before. Act in a way that's inconsistent with their position, enrich themselves, blah, blah, blah. So okay, what is your comment on that? Regarding regarding the finding that you had invented the inadvertent test.
I didn't invent my own words. This is the 2000 version of the code.
2007.
Eh?
That's the 2007.
Oh yes, the 2000 was speaking about willfully, and then the 2007 code, which deals with members may not deliberately or inadvertently mislead the president or the premier, or as the case may be, the legislature.
Yeah.
So I found, well, it was there in the 2007 code, and I must indicate that this 2007 code, on the 7th of February 2007, the then President Mbeki introduced significant changes to the Code of Ethics. So it was, he published a new ministerial handbook. So that's the information one has been having. And West, the Nkandla report relied on this code. All those EMEA investigations by my predecessor relied on that code. So hence, I also relied on that code.
Yes.
I never invented my own code as the public protector.
So, sorry, Chair. Thank you, Chair. Sorry about that, Chair. All right, now, Mr. Shabalala was saying that I must show that for the benefit of those who don't know this code, go to page 8, operator. Page 8. Is this page 8?
Okay, strong.
We'll come back to that page. Yeah. No, that's good enough. Every page, it doesn't matter any page. At the bottom of that page, Chair, you'll see the inscription there. Just wait there, yeah. Approved by Cabinet 7 February 2007. So I think that's good enough, that it shows two things. One, that it's the 2007 version, but also that it was at least at face value approved by the Cabinet. It turned out that the old one was applicable and so on. We don't have to go into all that detail, but it's just to show, I think really the reason why we're here is not so much whether it was the right or the wrong one. It's whether someone like the public protector would bona fide believe that this was the applicable code at any stage when it has that apparent stamp of approval by the Cabinet. I think that's good enough. Thank you, Mr. Shabalala. So let's go back then to 2.3. Yeah. Now, yes, you see the conventional wisdom in the school of thought that says that you were inventing this was that it's a ridiculous invention anyway on your part, because you can't mix together deliberately and inadvertently. But that's a matter for argument. But I think from what to say, President Mbeki, what they were trying to do, whether it succeeded in terms of procedure or not, or whether it was finally approved is another matter. But would you agree that this was an attempt to tighten the net, so to speak? So if the 2000 code was only saying if you'll be guilty if you willfully mislead the legislature, now they were introducing a new element to say not only willfully or deliberately, because that's a synonym, but now or inadvertently. In other words, it's like saying you may not kill a person intentionally, which is the law, but they also say you may also not kill a person negligently. That now tightens the net, so to speak. So you can't escape by saying, oh, well, I didn't mean to kill the person if you were negligent.
Yeah, I think that was a move towards making sure that people or the president is seen to be acting firmly and being decisive, because the 2000 code, when it says, especially on the misleading part, it says members of the executive are forbidden from willfully misleading the legislature to which they are accountable. So the members should show that or the person, the investigation should show that the person has given the incorrect information with the intention to mislead.
Correct.
So the incorrect information alone is not sufficient, but then it should be, it should constitute that there was an intention. So I think President Mbeki then saw the need that people who are serving as executive, you remember the high standard they should be behaving themselves.
Eye of the needle.
Yes, the one I've mentioned earlier, because you cannot just rush to go and answer a parliament without making sure that you go and investigate the matter, you get the response. I'll give the example of the Brown investigation, the previous Minister Brown, because I indicated that she inadvertently, she never made sure that Public Enterprises Department provides her with the correct information. She just went and presented that response, and it became clear that that response was wrong. So there was no intention, you know, but she was then kind of careless, because she should have made sure that the information she gets is truly the true facts. So I think the 2007 was then saying, you cannot just come and present and malicious compliance. I like to say that in the office, that sometimes officials will just do malicious compliance, but you need to be seen to be knowing what you, and you respect the decorum of the parliament, because they are the people. You need to respect the people. You cannot just go there and report and then life must just go on. So I think the intention was that, which was good.
Right. And incidentally, all these people that you mentioned, Minister Lynn Brown, Ms. Tina Jumat-Peterson, Diana Pule, and the others were, shall we say, censored or punished in terms of the quote-unquote wrong code, the tighter version that we've just seen now. What consequences do they suffer or seemingly suffer? And were those consequences reversed when it was discovered that it was the wrong code?
Not at all. I mean, as Van Rooyen, Minister Van Rooyen, previous Minister Van Rooyen, Minister Brown, during my tenure, there was no way. Well, we got a acknowledgement of the report, President acknowledging that I've implemented your report. I'll be relieving them of their duties. The also former Minister Malusi Gigaba. There's issues of the other ministers, but the issue is nothing was done. But at the end of the day, is that possibly Tina Jumat, Abu Diana Pule, there are other more, Bonkwana Mkhwebane, some of them went back to work, but the fact of the matter is, the intention is to know, because it's a lesson you learn. It's like a warning.
Oh, I did switch it on.
Oh, it's automatic. Sorry, I thought. Yeah. No, I didn't see that.
Please switch it on so that I will attend to this, because she raised her hand. So I'm the one who's opened mine and then yours was switched off. Please conclude.
Yes, I just wanted to say the intention, Advocate Bauer, when you switch it on, my one will switch off automatically.
I switch it on. I'm trying to get the chair's attention to raise an issue with my colleague, and the only way without actually interrupting him is to put the light on so that he can see. Because I don't.
Okay.
We can have two, but not three on at the same time. Yeah. Okay.
All right. Advocate Bauer.
Chair, the question posed by Advocate Mpofu presupposed that in any one of the reports to which he's referred, and I'm not for a moment saying that I know what the contents are, that any person had actually raised or discovered that the wrong code had been raised.
No, Chair.
In the way the question was phrased.
Yes. No, then
and I
I'm
just
sorry.
wanted him to clarify that.
No.
Because the question asked, did anybody do anything about it when it was discovered? And so it presupposes that anybody discovered it.
Fair enough. No, Chair.
Thank you for that.
Yes, thank you, Chair. No, that was definitely not, it was inadvertent. Yes, no, that was not my intention. My intention was, it goes to what the Chair was saying, that let's assume whoever applied the wrong code was doing it genuinely without some nefarious intention. So I'm accepting that if someone was fired because of the wrong code, it was not to get rid of them. Yeah. So let's put that aside. I'm now saying that assume that, and the public protector has said that there were consequences, ministers were relieved and what have you. Now I'm saying, let's assume you are relieved now. And then later on comes the Busasa judgment, which relieves all of us from all the misery and actually explains that the correct code is the 2000 code. Even at that point, you could either say, oh, I'm sorry, Minister Lynn Brown, you were relieved of your job wrongly. You don't have to rehire them, but at least simply say it was the wrong law. I'm at that level. I'm not doing it literally to say, I'm just, maybe let me put it this way. Was there any acknowledgement that those people may have been reprimanded or punished using the wrong code?
There was no acknowledgement. Hence, I said some of them were the ones who were found wanting under my predecessor's time. Some of them went back to be ministers. So they continued, and I hope they've learned a lesson. And again, taking it in that spirit that this code or this process, it's not supposed to be taken as if it's a punishment or it's a the power protector is abusing her powers and whatever. But the intention is you did this in future, don't repeat it again. But now, because we're going back to willful, and it's only purely on the issue of the misleading, because it's similar with the 2007 relating to any other.
Okay.
Okay. Anyway, I think we're fine with that. Then we're done with the article, the comparative exercise.
Yes.
I just was taking advantage of the fact that it was before us. Can we then go back to page 702, Seppo, where we were? Right. No. 702. Of PM10, sorry. All right, sorry, okay, let's go back then. Yeah, we just took that detour just to get rid of that issue. So in this, then the Phala letter, you then, as we said, obviously now quote the correct code.
Yes.
And you highlight the relevant parts. And I like that just as a drafting style. Yeah. So you give the full code in all its width. We were talking about the wide ambit of the code earlier. But at the same time, you put in bold sections C and F and G.
Yes.
Which obviously means those are the relevant ones for the purposes of this particular investigation. Yeah.
Yes.
And those, Chair, are C, members may not act in a way that is inconsistent with their position.
Yes.
So you highlight that. You don't highlight the willfully mislead the legislature because that's irrelevant
that's not
to
part
Phala.
of-
Yeah, okay. And then F, you highlight expose themselves to any situation involving the risk of a conflict between their official responsibilities and their private interest.
Correct.
And then you highlight G, receive remuneration for any work or service other than for the performance of their functions as members of the executive.
That's correct.
Okay, okay, that's good. I've been criticizing.
Then with the Busasa one, we then also included the first one. So if it was this 2000, we were going to deal with the willful misleading. But then
Yes.
because it was a 2007, we dealt with the inadvertently misleading.
Yes, very good. Okay.
Deliberately.
Now I'm saying I've been making snide remarks about how the office makes 5.3.4.5. So here now this is a compliment. I think this idea of highlighting the relevant parts, I think is a good idea. So the reader knows, the attention can be brought to the relevant parts. Okay. Excuse me. Then you quote the Busasa judgment.
Yes.
Effectively, again, having taken learnings from there. Okay. Then let's go to 703. Sorry, Chair. Press the wrong button. All right, then now you've landscaped, to use the chair's word. You've done all the landscaping, you've put the code, you put the act, you've put the constitution and what have you. You then come to the merits. So you then deal with the complaint, the actual complaint, yeah.
Yes, that's correct, because we should be, it's part of OD. It's part of informing the president or bringing the president into, well, informing him that there is this complaint and who lodged it and how it's crafted or how it's, it has been lodged and it deals with what issues.
Well, it looks like I'm in a good mood today of dishing out compliments. But how did you do all this work within a week? Because this is quite a lot of good work and extensive exposition. I mean, that landscaping is 7 pages or so. Or rather, what drives in an EMEA investigation in particular, what drives the speed? Maybe that's the simpler question.
Yeah, you're more than generous with appreciation, but that's now bothering to out of this what we're dealing with now. If she has to explain
how good it is.
yes,
No,
yes.
Chair, no, that's not the intention. The intention is to say is really to bring it to the EMEA mode. Yeah, maybe that's why I added that last part. Yeah.
Okay.
Can you explain? I mean, this, and I mean it seriously. This is seems to be an efficient synopsis, but the chair is right. That's just my assessment. What I want you to deal with is, given the nature of the complaint and the people involved and the EMEA and all that, when EMEA says you must do this within 30 days, what does it communicate to you?
It communicates the speed. I must indicate that this is relevant on a number of, well, as a case study, but we can even go back to the issue of the Busasa, the very same matter which is before this committee, and striving to comply to the Executive Members Ethics Act. On receiving the complaint, it was allocated to this chief investigator also, who was expected to at least draft the, we call it the evidence or the information request letter. Well, it's first OD actually, because then we bring it to the attention. So it was purely to strive to investigate the matter speedily. Yes. That's what I said, that during our various meetings, there was a time where I would say for task register, every week they should update me about the Executive Members Ethics Act complaints, trying to also lead by example, try to be compliant, because we're currently not compliant, and I acknowledge myself that is not the issue, and this was trying to improve as time goes on. Hence, in other investigations, for instance, we'll deal with that when we deal with the issue of SARS, the alleged rogue unit matter, where issues had to be split. There were 12 issues raised. Then we had to split that investigation and conduct the first part so that we can fast track EMEA. And chairperson, again, learning from where? From my predecessor. There was a PRASA, is it Transnet or derailed? It was Transnet or PRASA? PRASA investigation, where she did the first part and then I had to finish the second part. The main intention is to lead by example, investigate matters without delay. It has nothing to do with targeting people or, yes, I think it
Yes.
was purely that.
No, fine, thank you. And just so that the chair doesn't reprimand me again, if you go to 704, that same issue arises now, not as a compliment now, but as a loaded gun, as it were, from Mr. Zungula. If you go through, yeah, the last sentence here.
I
In-
think the chair is possibly Advocate Bauer wants to object, but she just tell the chair, maybe look into it. Yeah, maybe she doesn't want to delay the process. I'm just saying, I'm sitting here, it's her who tells the chair, and then the chair will tell you, but
yeah,
maybe
no,
because she doesn't want to
yes,
to
no,
raise
that
the hand,
happens
yeah.
a lot. That's fine. That's fine.
I'm endeavoring to catch the chair's eye so that I don't interrupt your speech.
Okay.
But at this moment, I wasn't doing anything. But if
No.
it bothers you, then I will go on record to do that.
Now,
No, it's fine.
the
It's
issue-
fine. It's fine. I think it's fine.
let
Tolerated
me
it.
indicate that you do not need to hold back. If there's any issue you want to raise,
Yeah.
please, boss, we're here for that. Get onto the mic.
Yeah.
I'm not always looking at you because I'm concentrating on these two.
The people
So I wouldn't
on the
say-
floor.
But don't hold back in going to your mic if there are issues. Doesn't have to be, you just do it for the sake of doing it.
Yes. No,
Thank you.
Thank you, Public Protector. No, Chair,
Yes,
it's something that has been bothering us, but I thought we should just turn a blind eye to it. I think it's.
No, she's not disrupting. So I
Yeah,
don't
no.
know what
I'm not
is
saying
bothering
she's
you.
disrupting, but she seems to be directing you
No,
as
no,
to what to do.
neither you nor the witness, nobody's directing me.
Yeah.
I am open to everybody here. So I don't want you to make any creations here.
No, Chair, I'm
of-
not
of
saying,
that kind.
believe me, I'm not
And-
blaming
and
you.
if that's what the Advocate Mkhwebane was saying, then I think I would have an issue with that.
No,
If that's what she was saying.
no, it's
No,
what
I'm
saying.
agreeing that possibly she wants to save on time. She doesn't want to object and press again because it affects my mic. That's what I'm saying. I was just showing the SC that, I'm seeing because she'll talk but not press.
Yes,
So I'm just clarifying to him that
Chair.
it's,
I don't think it's anything necessarily.
No, are you done, Advocate Mkhwebane?
no, I just wanted to say it's something possibly she wants to save time. She doesn't want to object.
Okay.
And possibly that might appear as if she's telling you what to do. So it will help indeed for her to object, as you say, so that we can know that
Yeah.
this is the issue to address. Yeah.
She's an advocate and a senior counsel. The worst thing she can be is to be a chair of this inquiry. Thank you. Advocate Mbofu?
No, thank you, Chair. No, thank you. I hope that will assist with that. Yeah, maybe sometimes, I do it as well, trying to catch her opinion, rather her attention. But it must not look like we are.
And I have, Advocate Mpofu, tried to catch your attention because
Yes.
whilst I don't want to raise the issue that about the leading questions where you're suggesting the answers to the Public Protector, and I have tried to catch your eye to show you that, listen,
All right.
without after each question trying to do that, because I also understand you
Okay, no,
trying to
that's
move
fine.
things quickly.
No, it's fine. I'll ask it differently if that was the question. Okay, what do you read into the paragraph or the last paragraph of Mr. Zungula's letter, which is at page 704, in relation to this question of speed that we're discussing, starting with the words given? Maybe read it out yourself, because if I read it myself, it might be seen as a leading question on its own.
So given the
I was just trying
seriousness,
to speed up.
yeah. Given the seriousness of this complaint, the ATM wishes to remind you that Section 3, subsection 2 of the Executive Members Ethics Act compels you to report on alleged breaches of the code within 30 days.
Right.
So that was directly from what the law is saying. And as I said, striving to do matters speedily. And not only to this complaint, but to any other complaint which is lodged under Executive Members Ethics Act.
Okay, speeding up some more. go back to 703. Okay, again, I won't go through the part in the italics. I was saying then, after the landscaping, you then get to the meat, which is 25.1. And there you say, in his complaint, the complainant informed the public protector that on 9 February 2020, there was a theft of millions of dollars and so on by criminals who colluded with your domestic worker, and that you concealed this crime from the South African Police Service and SARS, and thereafter paid the culprits for their silence. And then you go to the italics. And then at number 2, 704, having analyzed the complaint, the following issue was identified to inform and focus the investigation. And again, I don't want to go into the details. I'm just showing the format of how you do this thing. So you say what the complaint is, you quote from the letter of Mr. Zungula, and then you identify the issues now. This is now you speaking as the public protector, correct?
Yeah, that's correct. And I think maybe if we could have used the Busasa letter, I don't know, yeah, but it's in the report as well. That's what we captured. Definitely, we bring to your attention as the kind of implicated. You are not implicated as yet. This is still a very early stages of the investigation. We bring the complaint as is to you, because it's not something like we are hiding anything to you, but we're just showing you this is what the person has complained about. And then can you give us your side of the story? In fact, that is at the core of the issue of giving the party their side of the story.
Okay, then the rest is then the famous 31 questions.
Definitely, because there you need to remove the issue of investigating out of the box, fact-finding mission. You try, because always when we met at our task register meetings, full bench, or when we do file inspection, that's the key issue that Chairperson, I would say to them, take yourself to a crime scene. Well, we are not police, I'm not a police, but we normally see that when you arrive at a crime scene, you need to cordon off that crime scene. You need to make sure that you get all the evidence, any information you might get, maybe murder weapon, anything, DNA test and everything, so that at the initial stages, you have all the information. Hence, when we write that letter like that, we did the same thing with the Busasa investigation. We bring everything to your attention. And in the Busasa matter, let me go there, because I think possibly the challenge that we are using this one. As well, the complaint was from Mr. Mkhwebane. The president spoke about his son. We cannot allow the family and all those. But what did our investigation uncover? It uncovered that later he wrote the letter. It was his campaign. The son had nothing to do with that. Yes, we interviewed the son. So even here, we collate as much as possible, hence those 31 questions. And even it relates to matters which are falling outside of our mandate. For instance, the issues of alleged tax evasion, the issues of alleged kidnapping and all those. But we are doing that so that once we receive the information, then we go to section 6.4C, where it's either during the investigation, we refer, we say, maybe, Hawks, this is for you, we focus on this. Or alternatively, we collate everything, and then at the end of the investigation, even after the section 7.9, then we can refer that to other institutions if the need arises. So it was just purely doing that, and that's how we conduct our investigation, Chairperson.
Right. Okay. Then lastly, then on this, just maybe to illustrate that point, you can look at random, maybe you, some of the issues which you say fall outside of your mandate, which you did raise here. Yes. For example, about whether any tax was paid, that would be something that falls under SARS, not necessarily under your purview, but you are entitled to look at it from the point of view of maladministration.
From the point of view of improper conduct,
Yes.
remember as well, Amy, the behavior of the person in that position.
Yeah.
Are you holding yourself with what your responsibilities are?
Yes. Okay. I don't know if you've got it in front of you, but because I don't want to be accused of leading a leading question here. You can just pick out any issue that falls under that category, which you did ask.
If you tap, you can show. Tap, you can scroll up.
Step.
Oh, she knows, Chairperson.
The private deal. It's a private deal, Chairperson.
No, we are just joking. Advocate Bow. Yes, it was relating to the violation of the Executive Members Ethics Act, relating to whether there was theft of the US dollars in excess of 4 million, and whether you can just scroll quickly up. Yes, just a detailed statement providing an explanation regarding whether your conduct was in contravention of the Code of Ethics and the Constitution, because we are saying from your side, tell us, did you do that financial interest because it goes back to conducting work and that from your side, requested indicated the nature and value of the financial interest. Well, that deals with that, whether there was any cash to the tune of that money is an allegation. So that is what the source of the cash and all those, the permits, whether you can receive foreign currency and all those. So other things we requested again on the issue of how you conduct yourself as a member of the executive, which is very critical. You perform your duties and exercise your powers diligently and honestly. You fulfill your obligations imposed by the Constitution and the law, because all this also goes back to the issue of what the law is saying. The exact amount in rands of such other foreign currency, the date on which the cash was received. So these questions was making sure whether the cash was declared, because are you respecting the Constitution and the rule of law? From your side, tell us. So this was just a fact-finding a mission. How long was the cash kept there? Why was it not kept in a bank? And so any question, Chairperson, we ask. But at the end of the day, we then sift and make sure that we deal with what is within our mandate, and then we refer what is not within our mandate. Thanks. And they act in good faith, in the best interest of good governance. So purely checking whether there's any compliance to the Executive Members Ethics Act.
Okay.
Okay.
Thank you.
Thank you. Thank you, Chair. Yes, Chair, maybe let me just round off and then maybe we'll take a short break before I move on to the next topic. All right, so using then that kind of case study, and we know you testified before about what the court said about that you were suspended as a result of asking those questions, and in an act of retaliation and all that. Yeah. And I just want, before we take the lunch break, for you to relate exactly that finding by the court, the Western Cape High Court, which is now before the Constitutional Court, in relation to what we were discussing earlier regarding the, shall I call it, the dangers of a mayor, or the dangers of having these enormous powers in relation to your personal experience of why you're sitting there, and not just sitting there as a suspended person.
You know, thanks for that question. And to just indicate that, you know, sometimes having these powers, it's like a curse. Well, for me, I felt as if having these powers, having to investigate the executive, people who have the resources, well-resourced, then you are treated as if you'd want to, or you are targeting them, and was taking the matter to court, opposing, trying to bring to the court's attention what was the way or how we investigated the matter. I mean, it was good that when we opposed the matter, we full bench as a Western Cape, and where the outcome especially was saying the suspension should be declared invalid and set aside, and where the judges were mentioning that the suspension may have been retaliatory, unlawful, bias, of a disqualifying kind, and perhaps improper. This shows, and to the public actually, and I'm not scaring whoever will be my successor, but then I'm just pleading with the executive, pleading with the judiciary, pleading with the legislature. Members of parliament who are sitting here, you are here because the public brought you here. Never allow a situation where you are not acting according to what the Constitution expects of you, but also use this institution to make sure that you are promoting good governance. You are not dealing with, well, I said it the last time that yes, I'm sitting here, I'm example, possibly they need to make an example with me, or as a sacrificial lamb, but then my successors or generations to come shouldn't be treated like how I'm being treated. Use this law, learn from it. And I said it that any report we issue, learn from it. You don't have to take it as if the person is fighting you. And I'm still repeating to the public out there, anyone, the complaints are lodged by the members of the parliament. I am not fighting the president. And if the president is listening, I'm not fighting him. The judges who came to these conclusions, we did the best we know how, because what the law is saying, not to say we were targeting him, not to say I changed the code to suit the facts, not to say I went all out not to believe him, but if you've got evidence in front of you, what was I supposed to do? I conducted the investigation with the team. Unfortunately, the judges, as you know, the papers which were presented, and unfortunately for us, we also availed all the records. Yes, the challenge now, we will still deal with it. How we presented our case, maybe in my affidavit, but the fact of the matter is, you had the Rule 53. And you could see what was the intention of this investigation. It was not any sinister or targeting anyone. So that's all I would say about that.
And maybe just to round off before we take the break, using this case study that we just looked at now, and the 31 questions and what have you, would it make any difference? Would you have asked different questions if the president was Mr. Kubudile Janji or Mr. Kevin Mileham or whoever?
Chair, I'm objecting at this point.
Oh, sorry.
May I
My
Just
mic is
pause,
open.
advocating both for Honorable Milo.
Chair, we've allowed this case study, quote unquote, to go for an extended period. And it's far beyond the scope of this committee. Now, Advocate Mpofu is trying to bring in the 31 questions and what different questions have been asked and the like. And I really think that that is now beyond the realm of this committee. And I'm not objecting because you raised my name. I'm objecting because I think that this has gone too far.
Okay.
Thank you, Chair. And sorry, Mr. Mpofu, I'm addressing the Chair.
Yeah, so am I.
No, thank you, Honorable Milam. No, please switch off your mic,
Sure.
Advocate Mpofu. Thank you, Honorable Milam. I am very cognizant of that, and I deliberately did allow this space with the hope that it might buy us time later. But your point is a valid one, and I've taken note of that. And hopefully, we're now wrapping up this, which would have built a. I have no problem if it is about building a platform for
It is, Chair.
what next to come. So, but I take your point.
Yes.
Now, do you still want to throw your last question?
Yes, Chair.
Okay.
It really was. It's. I'm sorry that it's the one that has made. I should not have made an example of Mr. Malham being the president. He's just shown that that will never happen. Yeah. So no, I was just saying, Chair, that it was really my last question, and I take the point that Mr. Malham makes about the case study. I'm not even going back there. I was simply saying, okay, forget about the case study. Whether it was Pala Pala, whether it was Busasa, whether it was Rogue Unit, or any EMEA investigation. And it's in that context that I was using the issue of the 31 questions. I'm simply saying, would those questions be different? Because it's about the issue of targeting. Would they be different if the president was the chairperson or Mr. Steines or whoever it is? Would you have approached the matter differently?
Definitely not. I think Honorable Mailham, I think I'm just giving examples. I investigated I mentioned various ministers who were investigated. We investigated the former Premier Helen Zille, the current Premier of Western Cape. I'm just giving example that using the very Executive Members Ethics Act, irrespective of who the person is, we investigate, purely checking what the law is saying about that particular person. So I think that wouldn't change, or even if we were investigating any person, because remember, I'm not the one who's investigating. As we showed Matabuche and Bianca, the investigation is allocated to an investigator. Then it means I must, if I'm accused of being biased, it means I must tell them this is how you're going to do the matter, and any other person, irrespective of the evidence which is before us. Or if it's my favorite person, then you must not consider this information. So we do the work irrespective of who is involved, irrespective of, because that's showing independence. And I think if we can be, one chairperson can be allowed, because it's just trying to show, Honorable Maila might know about all those, is fine. But again, his constituents or members of the public will be listening and want to understand why I'm sitting here as the public protector, why DA lodged this motion and Parliament agreed to it. So it's purely doing that, and people to understand that I'm not going out there and look for complaints, Honorable Mailham. The DA, a number of complaints are lodged by the DA and opposition parties. You might be fighting your political space, but I'm operating in that space, unfortunately. So Uguti Ngaba, any other public protector, or maybe Mr. Van der Merwe or Ms. Pillay, with the current law, this is what they will be doing. If they are independent and they are honest and they operate with integrity. So that's all.
Okay.
Thank you,
No,
sir.
thank you for that, Advocate Mkhwebane. Just before we go for tea, for the 10 minutes of tea, just quick points to make to you, Advocate Mkhwebane, that we're now in the third day of your testimony. This is your time. And I think when you're there, I don't want you to be distracted by body languages. You are now getting a body language from your left. Soon it will be from your right. This is what I've been managing here because she's doing a job. She might be agitated or even irritated, as you always also do. So I'm here to manage those issues. So I want you to stay focused on what you really want to canvass this committee about. So let's take a 10 minutes tea break. Thank you.
Chair. By the way, I'm cool.
Andy Hasley.
that we won't even go to the evidence of those people. Let's leave that part out. Just on the 3 paragraphs, I just want to ask you a few questions. Firstly, you comment about the learning opportunities. What steps have you since taken since or let me put it this way, which judgment gave the definitive answer to this question of whether the second Audi must be given or not?
Is the Constitutional Court judgment, the so-called Busasa judgment?
Yes, and good. Prior to that, your office believed that there was no obligation to give this Audi. And again, in the mode of what we've been saying all along, doesn't matter whether it was the right or the wrong position. The question is whether you were doing it for nefarious purposes and good faith, or whether you were doing it because you hated certain people or whatever, or targeting them. Firstly, then, when the regime was not to give 2 Audis, was that for everyone, whether you liked them or didn't like them, or was it for selected people?
Maybe let me start by saying I know Chairperson SC would want to, but I would want to just explain that just for the benefit of everyone who's listening. In 2016 of October, when I joined the institution, engaging the team, the investigators, and the handover report of my predecessor, which was received, I think, a week after, there was no stage where we dealt with, okay, what way to proceed and how to deal with the matters. Then there was a stage where we were dealing with the template of the Section 7(9) notice and the report. And at the think tank, we then discussed. There are minutes to that. We can share. I think even they are uploaded on the Dropbox, where we discussed the issue of the provisional report. Because when I arrived, it was only issued as a provisional report. And that provisional report was issued in terms of Section 7, subsection 9. And that provisional report had remedial action. So it was the findings and the remedial action. Then we agreed at the think tank that we should now not issue a provisional report because apparently in the past they also used to even share that provisional report with the complainant. Then people ended up leaking that particular document or believing that people are implicated, forgetting that the implicated parties can submit more information. Then later, we then agreed that no, we're issuing a Section 7(9), a notice. It should read like that. So then the other lesson we learned was the Busasa matter, the CX matter, which we will deal with when we deal with CX, where that was issued, it had remedial action. Then it was also leaked to the media. We don't know even now who leaked it because we tried to investigate that. The case was opened. Now, when the Constitutional Court dealt with the matter, I was clobbered with personal costs, the fact that I didn't disclose this or you didn't do this. Then the legal services through Nemasisi, there's a legal opinion, I think it has been uploaded as well, where then he said, no, let's go back and determine what is Section 7, subsection 9 says. Because it's very clear that during the course of the investigation, that any implicated person on a matter being investigated may be to the detriment of, or if we find that there's...
Sorry, Pipi. I'm sorry, Chair, to interrupt. I think because this is an important section, can you put it up? You can carry on, but just put it up for the benefit of the members. The Public Protector Act, Section 7(9).
Yes, just to show Chairperson the background to this and that there were no ulterior or evil intentions in doing that. So then he gave a legal opinion, and the way it was done, for those who are legally qualified, it's like having the elements of, well, when in criminal matter, you'll say, what are the elements of a crime? You know? So even here, showing that, especially in 4.5 of that opinion, the requirements of affording an opportunity to respond is based on the following 4 elements.
No, I'm sorry, PP. I'm sorry to do this. I'm interrupting you for the second time. Can we do it systematically? I want us to go to the section itself, and then maybe we can use that opportunity for my team to find if the opinion of Mr. Namasisi has been loaded, to find it. So start with the section, then we'll go to the opinion. Yeah. All right. The check, I'll just read it out for progress. Section 9 of 7.9 says, if it appears to the public protector during the course of an investigation that any person is being implicated in the matter being investigated, and that such implication may be to the detriment of that person, or that an adverse finding pertaining to that person may result, the public protector shall afford such person an opportunity to respond in connection therewith in any manner that may be expedient under the circumstances. Okay, now you can take us on your understanding of that, not in a brief manner.
Yes, and then from that we said, what are the 4 elements? So the person must be implicated. Firstly, the person must be implicated in the matter which we are investigating, and the implication should be to the detriment of that particular person we are investigating, and there must be an adverse finding against that particular person. So actually, the Constitutional Court didn't say that. We normally say second audi. Actually, it's a third audi. Remember, we served the president with that letter. That's the first process. The second time was when the section 7.9 we issued. I had to go to Mahlamba Ndlovu. We had to discuss and show him the implications. Again, that's another audi. So now the Constitutional Court and finally decided that no, it's not enough, because here we were checking the implication. We were not dealing with the issues of we were dealing with the findings. And hence our section 7.9 will say, these are the following findings against you. Give us information or any other record which will show that you did not, or this complaint is not substantiated. Going back to that example of a person who's appointed with a matric, and the advert is saying a degree. Because as an institution or as a municipal manager, you must say to us, no public protector, our policy allows us. There's one matter we did in Limpopo where their policy was providing for the MEC. It was under the health, where the MEC of health can then cordon that particular behavior. So if the policy allows, there won't be any finding because you have complied. But in this instance where there's the implication and you don't provide us with a contrary evidence, then we'll have the finding. So the issue of OD, again, I don't agree with the way it's captured that I didn't give the president an OD. So this was how one did the investigation, working with the team and relying on the team and taking their advice. Hence the way we were doing our investigation. And again, why we changed from the CX and no longer issue remedies with the section 7.9, it was because also I was blamed that SAB, APSA responded, why didn't you meet with them? And or blamed that I didn't share the report with them, which is not true. We'll deal with those issues. Now we felt, and you put this remedy, and that's what happened in SAP. Then they respond, they advise you accordingly, they convince you actually, because in SAP we will show that National Treasury convinced us. We had to change that remedy. The presidency convinced us. We had to change that. Now the challenge is, again, it means we were supposed to go back to those parties again and give them another Section 7(9). So the decision, the Masisi investigated and said, but this is the proper interpretation. Yes, it means the Constitutional Court says, no, you were not correct. And we take that and it's fine. That's what we are implementing currently. But there was no sinister motive at all.
Yes, thank you. Okay, so in summary then, going back to the case study without causing any chest pains, you say that the 31 questions, so to speak, is what you call the first audit. Then when the findings happens, it would be the second audit. And then now what is the court basically saying is that you should have a third audit, quote unquote, after the remedial action has been determined. So that's the current position.
That's, I think it means that, but what is currently happening before even the Concord finally issued the judgment was that we started then issuing the Section 7(9) with the remedial action. So for expediency, not to say we will issue without remedies, you respond, then we issue with the remedies, you respond. No, what now we are doing is that we issue the first audit when we request documents from you, bringing the matter to your attention. Then we issue it when we have a Section 7(9), and then we include the remedies there. So I hope we won't have challenges because once we include the remedies in the Section 7(9) and we issue the report, that's what we've been trying to do. Even there are some matters which we had to fast track. There are minutes to that. We full bench, backlog matters, how to fast track those matters. When we serve you with the Section 7(9), we insist that we need to meet with you, because what I've picked up is that when people are responding to the Section 7(9), sitting in their offices of being advised by their legal services, their reaction is kind of antagonistic, because they're saying, no, she's wrong, she can't, and not deal with the finding, what your policy is saying, and why we came to that. So when we meet with them, it fast tracks the process. We then explain to you that these are the findings, but then to correct that, we are proposing you to do the following. So that's what we are doing or trying to do most of the time. And I would call upon any institution, when you are investigated, even currently, when you are issued with a Section 7(9), request for a meeting with that investigator or even the Deputy Public Protector currently. Well, I'm just calling upon people to do that. Public servants, DGs, even the minister or even president, sit down, understand, why did you come to this conclusion? And we will show you, but the law says this. Here's your policy. Here's the evidence. Hence, we have that. That's what we did with Minister Mbalula when he was the Minister of Sport, because we sat down, we showed him everything. Unfortunately, our hands are tied. This is what is happening. These are the findings. So that is being done. Not to say we have any things we are doing in private or in secret, but we engage you fully. We even show you, demand of those meetings, let them take you through that. Yeah.
What Professor Madonsela referred to as a T. So you allow for T as well?
A T, well, if you're doing investigations, then it means that T must be with the investigation team, and they should also participate in that particular T.
Right. Okay. Now, the issue then is, and Chair, I'm moving on to something else, but I want to flag this because, as you know, Chair, this is a recurring issue. Whether you are talking Freire, whether you're talking CX, the 7(9), most of the complaints are around people complaining that I was not told this, I was not told this, I just woke up and there was remedial action, and that kind of thing. So let's leave it there because we will come back to it in other contexts. Because it seems like the recurring themes in the complaints is this thing about expanding or reducing the mandate generally, and then this issue of this one was not given an adequate hearing or a second audio or a third audio or whatever. Right.
Yes, I think a number of matters which we will be dealing with, though then each matter has its own facts and merits and explanation, but it cuts across.
Correct.
Or I'm being blamed that I'm not giving people an opportunity. And again, we're still reading that the implicated parties, because the person we are investigating, the person who has the responsibility in terms of that law to act when there's any maladministration.
Yes.
Because normally when we investigate that advert in the municipal manager office, we will write to the accounting officer and we serve the section 7(9) to the accounting officer because they failed as the accounting officer. And the accounting officer is the one is expected to then go to the HR manager who failed to make sure that they comply to the policy. I don't know whether you get me, Essie.
Yes.
So in an institution, we won't write to each and every person who was part of the
Affected.
HR manager, and then the panel which interviewed that person. Normally we would say, you as the accounting officer, you need to deal with it. But then if we will be expected to issue a section 7(9) to each and every person, then it means, well, would rather close shop because the institution won't close any matter.
No, thank you. Thank you, Chair. Yes, I know I've been promising to move on, but I do want to close this issue. That point you're making is also important because it's also cross-cutting. And I just want to flag it. For example, it looks like, I mean, you know, we're a constitutional democracy, so we all feel entitled to be respected and given our rights to a hearing and all that. But you've read the section. I think your point is that there is a limit, and the section limits it to
Implicated
to
parties.
implicated parties. Sometimes it's the same complicated parties, yeah. But the implicated parties, I mean, that issue seems to be playing itself out in various ways. And I'll give examples. In the rogue unit matter, you know, we raised it with Ms. Mkhwebane and other people. It became necessary to explain whether Mr. van Lochenberg, for example, is an implicated person and therefore entitled to section 7(9). And Ms. Mkhwebane explained why that was not done. Did you regard Ms. van Lochenberg in that investigation? I know we'll get to rogue unit tomorrow, but did you regard him as an implicated party in the sense envisaged in section 7(9)?
As we explained, and I think Mkhwebane explained as well, that the matter was split into two. So there were 12 matters or 12 complaints, and we then had to split the investigation into two. We dealt with 6 matters when we issued the report. So this other 6 was going to deal directly with the issue of Mr. van Lochenberg, because he was directly mentioned and being implicated. Therefore, he was supposed to be given an opportunity in that particular matter. I think that's one of the reasons when they couldn't find him, and also advising them, did you check the court, he's appearing in court, what other measures? But we said
subpoena.
The subpoena, yes. We couldn't serve the subpoena, but we said anyway, because there's part 2, we will still have to trace and find him so that he can give us his side of the story, especially on the monies paid and everything. Yes.
No.
So, but in the first investigation, he was not. And we had to serve it to the accounting officer and the decision makers.
Yes, maybe let's do it like this. The first part was the EMEA investigation.
including few other issues
Few,
of the
yes.
appointment of the unit.
And so on.
The
The other
procurement.
part was non-EMEA.
There was no EMEA.
Okay. Was he implicated in the first part?
No.
Okay. So okay, fine. Let's put that aside. We'll deal with it when we deal with rogue unit. I was just flagging that as an example of this whole 7-9
Of who is
issue.
implicated, yes.
No, of everyone claiming to be entitled to Section 7-9. The other example is in CX.
Hmm.
You'll remember,
The Reserve
I think
Bank.
it was Mr. Chiwalule or one of those witnesses. Yeah. You'll remember again, there was a whole thing about Mr. Hoffman now.
Yes.
Also taking the PP to task. Why was I not given the Section 7-9 notice? And unlike Mr. van Lochenberg, in that context, Mr. Hoffman was the complainant,
Yes.
not the implicated party. And again, he was not given a 7-9, and I think he was told politely that actually he was not entitled to it because it was he was a complainant. Now, the question is, and as I say, I think it is to be expected. To the extent that all and sundry would require to be given an Audi, and I think one of the charges actually incorrectly refers to affected persons, not implicated persons. In other words, everyone who's affected must be given an Audi, which is not the law, but that's just an aside. Yeah. To the extent that all and sundry would claim this Section 7-9 non-consultation and what have you, how did you deal with that, with those demands from people whom you did not regard as implicated?
I think starting with Mr. Hoffman, actually, he even complained to Parliament Justice Portfolio Committee as well. One of the people who complained about me not giving him the report, not doing my work properly. But yeah, it's all those. But he was told that we're doing this in terms of Section 7-9. We are giving the implicated parties an opportunity to respond. And once they respond, we will be the first one to receive the report, the final report, because again, it will take both sides of the story. We cannot have this evidence, this conclusion, and share it with you, because when I arrived there, again, listening to what has been happening, where some of the provisional reports were leaked, the complainant will say, yes, I was right, the institution was wrong. Then you find that the evidence, or when the institution responds, that is not the situation. So any person who has lodged a complaint with the public protector, you do have the right, because that's why we issued the rules. And again, we didn't have the rules for all those years. I'm the one who made sure that we finalize and issue the rules. Those rules of the public protector, they are there for the members of the public, for the public servants. You should know them, because the rules are saying, as a complainant, you have the right to receive feedback on the progress of your investigation. And if we don't have any findings against the institution, we can only give you what we call a discretionary notice, or where we say your complaint is not substantiated. But when we issue a Section 7-9 notice, is only for the implicated parties, people we were investigating, people who violated the provisions of the law or even their policy. So I would say they are not justified to demand the letter, that particular information.
Yes.
And I think there were a lot of other concessions when I arrived, though we didn't give that as an example or the matter. There was a matter of IEC building. I think against the previous CEO, Pensi Tlakule, that matter, we had to be convinced by one of the SCs that don't oppose it, settle it, because the previous investigation, or my predecessor didn't even serve the notice to the implicated parties, because they were implicated. So we had to then agree that, okay, let's not oppose the matter, let's settle it. Yeah. So it goes to that extent. It depends on the implication of that particular person, not the affected person.
Yes. No, thank you. And again, I think in the spirit of what the chair was saying, we'll assume that those people who are making those demands were doing so in good faith, because not everyone scrutinizes the section. They just know that they have a right to be heard generally, although you'd expect more from Senior Counsel Hoffman. But the point is, and this is a point we will make when we deal with the second statement. Chair, by the way, I forgot to confirm in the morning that the second statement was deposited yesterday, just for the record.
We have received it, and I think it has been dispatched to members.
Thank you.
So thank you for that.
Thank you, Chair. Yes, sorry. Yeah, in that second statement, the second installment of the statement, there's a section, a small section where we deal with what we say the defects in the charges. So I'm again trying to dispose of that. Tsepo, if you can go to bundle A, page 2. That's the charge sheet. Right. I'm doing this in passing. I'm not going to dwell on it. We'll deal with it when we're dealing with CX. So you see there that you have a number of what the independent panel calls subcharges. So you have charge 1, and then the number of subcharges effectively of what you are alleged to have done, this and that and the other. Yeah. But one of the charges uses and I just want to comment in relation to what we're discussing now about implicated parties versus so-called affected parties or parties involved in a matter. You are accused of misconduct in relation to the CX matter because you, in the conduct of that investigation, you 1.1.4, yeah, that one, failed in her duty to give affected persons, including the Speaker and the South African Reserve Bank, both prominent role players in the affairs of the state, whatever, notice and an opportunity to comment on any findings or remedial action she proposed to take, with the consequences that they were severely damaging not only to the economy, but to the reputation of her own office. And my simple question at this stage, we'll deal with it later when we deal with that, is do you regard yourself as having any legal obligation to give Section 7(9) notices to so-called affected persons?
No, not affected persons, to the implicated.
Okay.
To the implicated persons.
Yeah.
Because that's what the Section 7, subsection 9 says.
All right. Thank you, Chair, for allowing that detour. Hopefully it will save us time tomorrow. Or whenever we deal with the second statement, sorry.
So in the context of a suggested constitutional amendment, the Speaker will be implicated.
That's a good question. Yeah.
The Speaker will be affected, not implicated, in the sense that, remember, we'll deal with that matter, Chairperson, because let's deal with that in the issue of context.
I'll park that. Yeah.
Yes, please.
Because I'm just after seeing that,
Yeah.
was it
Yeah.
also refers to the speaker,
Speaker.
that's affected?
Yeah, no, that's an
Affected.
interesting question. Pablo Sosa, can I prevail on you? I'm now abandoning you. I'm representing the chair. Can I prevail on you that we deal with it now briefly? Because I think it's a very good example of this distinction between an implicated
Implicated
person
and an
affected
affected.
person. Yes. So what the chairperson is saying, like, yeah, you have this situation now. You say, whatever, for good reasons, forget the CX thing. For good reason, you find that this legislation must be changed because it's affecting the poor and whatever you. And then you do a section 7(9). Do you, and let's not talk about courtesies and all that. I'm talking about matters of legal obligation. Yeah. Do you have a legal obligation in that example, which I've just made up, to, when you issue a section 7(9) to the real implicated person, someone who messed up with that legislation? Would you then have a simultaneous legal obligation to issue that section 7(9) to the speaker as well? Because the chairperson is right. Ultimately, the speaker is going to be in charge of the remedy. Yeah.
Not dealing with this particular matter. As I said, the issue of context is very much important.
Yeah.
Where we are, let's go to the example in Nkandla
Yes.
judgment, the Nkandla report, secure in comfort. We'll have to just check. I wonder whether the speaker was served with the section 7(9) notice, but we will have to investigate that. I think we'll come to that.
Okay.
I'm
That's
just
fine. We
trying
can
a
deal with it.
situation, SC and chairperson, where the remedy was to amend the legislation. Because I know my predecessor's remedy in the Nkandla judgment was that they need to amend the Executive Members Ethics Act and to deal with when a complaint is lodged against the president, who do you inform if you haven't done the investigation within 30 days? Currently, the practice is we just inform the speaker.
Yes.
But I don't remember, if it's a policy, we don't go to the speaker, we just go to the DG, to the accounting officer.
No, let me come in,
Yes,
so that
sure.
I don't delay
Yes.
your trail
No,
of
I
thought
appreciate that.
and your what you're doing.
Yes.
We can park that and come to it later. Might also help
Specifically.
you to slip over it, because I'm taking it directly from what you
That
have just placed here and putting it into a particular situation, because his argument, which I'm not going to get into now, we'll have to deal with that later, is this issue of people being affected. It's not in law.
Yes.
Basically,
There's no legal obligation. Correct. No, the chair is right. I think let's park it. The chair, I think let's park it. We'll deal with it in the morning, because there's also another spanner in the works, especially with EMEA matters. Remember, there's also, if it's an EMEA matter, in any event, you have to inform the speaker, because the executive accounts to Parliament, and so there would be a difference with non-EMEA matters. I think let's slip over it. We'll but it's a good example, I think, to illustrate this point of affected versus implicated. Yeah.
So, but maybe for now, we looked into the direct provision of section 7(9), or by then, honestly, I was just looking at what the section 7(9) saying and the legal opinion. Yeah.
Yes.
But we will check into
no,
that.
it's very interesting stuff. Also, there's this stuff about reporting to the president. So what do you do when it's actually the president who's accused and so on? So all those questions, okay, we'll deal with them, I think, in a more organized manner. Right. Okay. Can we then move on to the issue of jurisdiction?
Okay.
Again, I'm not going to spend a lot of time on this. You'll remember that one of the big issues, well, it might not have been big for you, but for the public out there at least. One of the big issues on the Busasa matter was this whole issue as to whether you, the Public Protector's Office, the president took the technical point that your office doesn't have jurisdiction because this money, even if it was given, even if it was 100 billion or whatever it was for political party activity, which is quote unquote private activity. And therefore, whatever the amount was, it didn't fall within the jurisdiction of the public protector. I'm just paraphrasing the defense, and that's the court upheld that defense. Of course, Chief Justice Mkhwebane has very choice words to say about who was actually the beneficiary of the money and who was going to be elevated to the position of president and who was the deputy president and so on. But he was in the minority. Now, can you just comment, because we don't have a lot of time, as to the process by which you and your investigators and your office determined that you do have jurisdiction? We know that the court found otherwise, and we you know, for now we have to accept that. But the question is whether you, again, you were just hunting for this person, and then so you even overreached where you don't have, straight over where you don't have jurisdiction. Why did you determine that you have jurisdiction in this matter? And instead of just saying, oh, well, Mr. Maimane and Mr. Shivambu, I don't know what's wrong with them, because this has nothing to do with the public protector. This is about some political party somewhere in Nasrec. Why?
The complaint was lodged in terms of EMIA, Executive Members Ethics Act, which obligates the public protector to investigate. I cannot just say, no, I'm not going to investigate. Hence, we had to determine whether, when the complaint was lodged, again, it goes to the assessment section of the institution. And since it's Executive Members Ethics or EMIA related complaint, they know they need to open a file allocated to an investigator. In this instance, I said, because it involves the president, let it be allocated to a chief investigator. And the investigation was conducted. Now, is the president at face value? Everyone will think, okay, the president, yes, must account. We need to investigate the president. Yes, indeed, it was complicated because it involved party political issues. And hence, we had to conduct preliminary investigation, do research, ask for legal opinions. And then, boom, it transpired, no, this happened when the person was the deputy president. And as a deputy president, you are a member of parliament. And as a deputy president, you are, or any member of parliament, like any other one who's sitting here currently, you need to declare whatever gift you have. And we had to even write to the speaker, request any declaration. And that's what we did. It was not at all a fact-finding or a fishing expedition or trying to, you know, target the president. No, but our investigation then uncovered such things. Hence, it's very critical that we conduct a preliminary investigation, which is part of investigation, because in the definition of the public protector, preliminary investigation is part of the investigation. And when we account to the portfolio committee chairperson, you know, we will indicate which matters we received. Where we don't have jurisdiction, we don't just not mention them. They know we will mention them And I like it because my predecessor used to do that, which is supposed to be like that. We did work. We received the call. We spent some time. Therefore, even in this one, we received, analyzed, researched. Then we discovered, no, this matter, we have jurisdiction. That's what we thought. And well, I still think like that because he was the deputy president. He was supposed to declare. But now, yeah.
Yes. And again, in that view, correct or incorrect, you are in the company of at least Mr. Mataboge and Chief Justice Mkhwebane. And again, I'll ask you for the sake of completion, because you've answered the question at a broader level. If the Chief Justice and Mr. Mataboge, who's in terms of the Public Protector Act, to be presumed to be independent, because the Public Protector Act says that any official there must be independent and unbiased and all that. And no suggestion was made that he was not. So if two independent persons, Mr. Mataboge and the Chief Justice, came to the same conclusion as you, and they have not been impeached or anything of the sort, why do you think you can be singled out from those people who come to the very same conclusion based on the same facts, rightly or wrongly? Let's say wrongly, because the one is in a minority judgment, the other one was overruled by the court.
You know, again, maybe let me start by saying, you know, losing, well, it's there in my statement, in court on a point of law, because yes, we, from my side, after Rodney Mataboge investigated, and finally the Chief Justice going through everything and our reasoning, what happened, what should have happened, is there a discrepancy between the two? What is the law saying? We considered all the laws. We found that there was then a substantiated a complaint. And unfortunately with me, again, I'm not treated like any other person. As you would see in a number of cases, the way the comments about the investigations which we've conducted, while the buck stops with me as the public protector, because the constitution said the public protector must investigate. And I hope and I pray that this process, again, I'm still saying my successor will have it smooth, because I'm an exemplary. And I hope the judges are also listening, the judges, clerks, and everyone. They should understand how that office operate. We don't just wake up and just take what the media says and just investigate. So unfortunate that sometimes you find that some of the judgments from, well, I will mention Judge Bakwa, who was the public protector, who would understand how investigations are done. Some of them, well, it was concerning. But unfortunately, I don't think it should be fair that just impeached for that.
Yeah.
I think that was done innocently, honestly, and the best we know how. It was not a fishing expedition, or it was not an intention to target the president. But till this day, he was the deputy president. He was subjected to that particular law.
Yes. And assuming now for a minute that he knew about the gift, he received the gift, he participated in their distribution and so on, did you find that those gifts had been declared?
No, our investigation revealed that there's nothing which was declared by him.
Okay. Right.
Because when we conduct the investigation, as I'm saying, in the file, the letters which were written to check, Was that done? And I mean, it's a public thing as well. Any member of the public, you must check whether the people who represent you here in Parliament, have they declared whatever they say they should be declaring, because that's part of ethical leadership. That's part of transparency, accountability.
Yes. Okay. Talking about transparency and accountability, would you care to comment on the, shall we call it, advisability of someone in that position then reacting? We've already spoken about reacting by taking technical points. We dealt with that last time. But reacting by actually getting the evidence that you've referred to sealed away from the public eye.
I think for his own benefit as the constitutional being, I think it would be advisable for the president to operate in the spirit of transparency, accountability, and removing any doubt and any unnecessary, inferences which people are making out there. I think it was the way it was even done. It creates a lot of suspicion. And I think it doesn't sit well. Leaders should be leading by example, should be 100% compliant with the Constitution, because when they take an oath of office, Section 95 of the Constitution, you abide by the Constitution. So any provision of the Constitution as a president, hence I'm saying you are a constitutional being.
Yes.
I think that should be done. And I think in my statement, I also mentioned, besides that issue, I know you've moved, that the worst thing for me to be marked with cost order in the very same matter, and considering the fact that, you can't just subject a party participating openly and assisting the court. Now you have to pay personal costs. Well, in this one, it was a cost order against the public protector. Those are state resources, which unfortunately we also belong or benefit from the same fiscus. Now we need to pay those. And unfortunately, that's one of the charges here, so which we will have to deal with. Where are we going as a country? One organ of the state.
Yes, well, okay, happily in this one, while the High Court ordered you to pay costs on the punitive scale and so on, at least the Constitutional Court reversed that order.
The High Court did, yes.
Yes, well, the Constitutional Court actually ordered no party to pay the costs,
yes.
I think, because it said these are public, everyone was acting in the public interest, and the money actually comes from Treasury.
And I hope it's a lesson for the lower court, especially the High Court, to take note of that.
Yeah. Chair, sorry, again, let me just flag that issue out. Yes, we don't have to go there just to save time, Chair. I'll just read out the order or the part. In terms of costs, it referred, the EFF was ordered not to pay anything because of the biowash principle. And it said the rule does not apply to the public protector. And then the court said, paragraph 147, the position between the public protector on the one hand and the president, speaker, and the NDPP on the other hand is different. Usually the parties that are successful on appeal would be entitled to their costs, and the by-watch principle would not apply between organs of state. However, all these parties use public funds to fund this litigation. If one of them is ordered to pay costs effectively, it will be the public which will bear that liability. In the circumstances, I consider it fair not to make a cost order.
Which was a perfect, I mean, I think it should be like that on all the matters which we've been litigating, but unfortunately I'm charged for issues of wasteful expenditure and everything, where even when I'm not participating in the procurement, but that was very fair.
Yes.
Actually, it's one of the best, and I hope every judge can learn from that.
Yes, thank you. Yes, and maybe just to correct myself, the Constitutional Court did not reverse the High Court order, but at least as far as the appeal is concerned, gave this order which you are happy with here.
Yes.
Okay, right. Okay, just for the sake of completion on the issue of the sealed documents, is there an explanation that you can think of why the president would want this information sealed regarding the donors that he does not know, according to him?
I think the way it was done as well, because it was a letter written by the president's attorney to the deputy judge president. And it was something which was done in chambers. And from our side, we were saying, let this matter be dealt with in court so that we can hear all the facts and deal with this matter openly. And that was done with the intention of saying, showing that we relied on information. It was not just something which we woke up with the team and said the president is implicated. But the report was issued because we had the evidence proving that they are these donors, they are existing, the ones which we showed the other day, and they've paid so much money, and the president knew about them. So it was purely to just assist the court. So we were thinking the court will, for justice and issues of transparency, accountability, because that's what is expected of any other court. So I was then surprised when they were sealed, and that's history.
Yes. And again, I don't want to belabor this point, but I want to differentiate between me, if Mr. Chabalala and Mr. Kosana give me gifts, well, I don't have to reveal that to anybody if I want to keep it secret. But if I was the president of the country, subject to EMEA and all the things that we've gone through, what message would it send?
Hence, I said it will raise suspicion. Those who would want to have ethical leadership, and especially as a country where we have a lot of challenges of dealing with crime, challenges of dealing with corruption, and where we are trying to deal with the so-called state capture, which is a crime, because it's an issue of one, giving a gift so that they would want to expect something in return. So I think it leaves a question mark, or it leaves something hanging over the president's head to say, but why don't you want that to be revealed? Because you need to be transparent in your dealings. So I think it's just a matter of ethical leadership. Yes. Lead by example.
And thank you. Well, on that, the act, and unfortunately, Mr. Ngola is not here. And I think we all forget that Actually, that's what this whole thing is about. EMEA, as Mr. Ngola will now testify, stands for Executive Members Ethics Act.
Definitely.
Ultimately, it's not about tick boxing, and it's about ethics. So from an ethical point of view, maybe my question is, what is the difference between ordinary Joe citizen like me and someone who puts themselves up to become the president of the country, or a minister, or an MEC, or a premier, or whatever?
Because we are dealing with the Executive Members Ethics Act, definitely the standard of, or we have high expectations on you. And whatever you do as the president, anyone will take, you should be leading by example. Anyone will take a leaf from you, taking it back to families.
I think, can we have one inquiry?
That whisper is a bit loud, so we can hear it, that you're whispering. So I'm going to ask that whoever is whispering, you're disturbing the witness. Thank you. Proceed, Advocate Mkhwebane.
Sorry, Chairperson, I will try to focus. You said I must focus, but I couldn't, because now it's competing with my, I would shout, Gandhi, yes. So I think you need to lead by example. In any family, I mean, we've got children. A simple example, well, being a Christian, the Bible says a child does what the father does. So I think if inkala ihambi chekile, nabantwana nabo bazohamba bachekile, so you can't beat the children and say you need to walk straight when you are not walking straight. So I think ethical leadership, it's that, but it filters down to how as citizens we should be conducting ourselves. So I think it's purely that, yeah.
Well, thank you, Chair. I think that needs translation. What you are saying is that, yeah, if the crab walks in a skew way, it cannot expect its children to walk straight. And maybe we stop it on that amphibian note.
Completely, it says it cannot force its children to walk.
Yes, that's that's even better.
More than expectation.
Yes, yes. It must lead by example,
Yes.
in simple words. Thank you, Chair.
All right.
Yeah. Chair, yes, on that, what was it, crustacean note, can maybe it's 5 o'clock, Chair. Could we, if you just allow me 5 minutes just to wrap up? Yes, thank you. All right. Okay, now Public Protector, we have then oh no, yes. I'll use the 5 minutes for this. We did deal with this briefly. Maybe just to, there was this issue about whether it's breaker or poker. Do you accept that the correct act was not quoted or cited in the report?
Yes, I think that I indicated earlier that the era of law with the judgments is happening. The era of the public protector, if we have not followed the process, especially the review process, it's also happening. In a proper democracy, they should have, or in a proper justice system, the report would be returned back to the public protector and say, the matter is reviewed. This issue, because remember it was relating to the referral issue. And again, that doesn't fall within my mandate. The main intention was that there is that prima facie information. NPA, because it falls squarely within your mandate, go ahead and do that. But unfortunately, then it was magnified to such an extent that it became the only thing which we deal with. So hence I'm saying it's neither here nor there, but I acknowledge that we should have mentioned the correct legislation.
Correct. Thank you. And I think similarly to you, we've all gone through the 2000 and 2007 version of the code and what have you. But do you accept that whoever was drafting the document, and I think Advocate Bauer has referred to this previously in another context, I think when she was questioning Mr. Matabuch, that it would seem that in certain parts, and I think she correctly said there were like three versions. In certain parts of the report, it's the correct code where you say President willfully misled Parliament. And then in other parts, it will say willfully and inadvertently. And I think there's even a third version that says willfully or inadvertently. I'm saying now, given, and therefore that's what gives the impression, which was not picked up even by the court, by the way, but gives the impression that even instead of using the wrong code, it's as if you're using both codes. Now, do you accept that as a drafting error, so to speak, that something like that should not appear in a report?
Yes, I agree, SC, and I think it was also as a result of, I mentioned earlier, where Advocate Bauer showed that email Matabuche sent the draft, and I was saying referred to the 2007 code. So it means he referred to the 2000, worked on the 2000, and when I said check the 2007, then both codes were used there. Actually,
as a matter of fact,
yes, as a matter of fact, the report is there, it's very clear. But it's so unfortunate that the court only focused on then the deliberate, or that I changed the code. And I still repeat, we've shown the two codes. I never changed, and I gave the Constitutional Court an opportunity for the rescission because it was a clear mistake which they did. Unfortunately, that judgment still stands. Unfortunately, anyone who would read that judgment will think this public protector, you know, she thinks she's so powerful that she creates her own. I mean, she hates Mr. Ramaphosa to such an extent that she created her own code just to have a finding against him. But I hope that is clear to every South African and the world at large that I never created any code. Those codes were there, both of them. And fortunately, they were used both, because if it was somebody who was very fair, judging this matter would have seen as well to question, but PP, somewhere you say willfully, somewhere you say deliberately. So yeah.
So, okay, I was looking for those passages, but as I say, Advocate Bauer referred to them. Yeah. And again, yes, if indeed this was a case of somebody who's going out there to reinvent or invent the code, would you have at other parts of the report actually referred to the 2000 code? What does that indicate?
Well, I would have made sure that throughout the report, I'm using this deliberate and inadvertently or deliberate misleading of Parliament. You know, even when we were laughing that Mr. Matabuche was not techno-savvy, but when it comes to drafting, he's brilliant. And he made sure that his documents are properly drafted. So he would have made sure that he searches everywhere where there's that willful. If it was my invented matter, he was going to make sure that. So unfortunately, that's what transpired. Yeah. But the main thing, again, what people forget is that we were checking the conduct of the president. And we were trying to correct that. Whoever is currently president, when you go and answer questions, and the people who are advising the president, just answer, even the deputy president or any minister, answer what is asked, leave. When there's follow-up from opposition, don't answer and request them to be in writing, because that's what your rules are saying. When you want to correct, can Parliament Speaker amend your rules so that you give an opportunity to that? But as we said, President Begi was of the view that if we say we need to lead by example and be firm, we need credible and ethical leaders who would be honest when they treat or respond to Parliament. Yeah, it was purely that.
Yeah. Then maybe finally on this is for you to explain why you say if there was no emir, you might not be sitting where you are sitting. Why is it the albatross, so to speak, that you've had to carry?
Hey, the albatross, you can say that as a chairperson, through you, chairperson, yeah, because you know, if you are a president of the country, you have all the powers which you should be using institutions like us to help you to lead ethically. It might not be the president, because possibly even some people who are surrounding the president would then want to, you know, deal with you. But I feel that this is one of the things which made me to sit here as the public protector. Secondly, then is the Nkandla judgment. I know you are one of the
I was on the other side. Yeah.
Yeah, but I think the ombudsmanship, the remedial actions, the binding nature, because then people feel I'm losing face. I can't be told by the public protector, therefore we need to perpetuate this thing that she doesn't know the law, she's incompetent. Forgetting and then just promoting that and vilifying you and forget about what you should be doing. But EMIA then makes me to say, be persecuted by the untouchables, which are the members of the executive.
Yes.
Because well, some have issued very derogatory statements against me, others calling me a hired gun, others are calling me a rogue public protector, all in the name of just doing my work. And the biggest mischief is Executive Members Ethics Act.
Yes, and yes, in fact, we've, I think, correctly expanded the question to include the Nkandla judgment, because it's not just EMIA, it's that combo, that toxic combination or dangerous combination of the powers that you have from EMIA, now even more enhanced by the powers that are brought about by the binding nature of your remedial action in the Nkandla's judgment. And that goes to Honorable Sokoni's point, and I think we can close it on that. Whether then, given those two double-barreled weapons in your hand, EMIA and the Nkandla judgment, what your view is on Honorable Sokoni's proposal that it might well be that what we were celebrating as the Nkandla judgment's achievement of the binding powers is a poisoned chalice, in the sense that those double-barreled powers of the public protector then cause the situation that we now see in South Africa. So the question is, do you agree with Honorable Sokoni? And I say this was a wake-up call even for me, because I couldn't deal with it, that maybe, obviously not now, the future legislators should relook into the question of whether or not powers of the public protector should be binding or recommendations?
I think I agree with Honorable Sokoni, and I remember her evidence also for those who have gone through it, members of parliament, and I hope they are learning from this process, because whatever is happening, indeed, let's take it in the spirit of doing it for the generations to come, a better country, a better legal system. So worldwide, I said it, even we are one of the few countries where our remedial actions are binding, I mean, through the Constitutional Court. And Africa looking up to South Africa, Zambia followed suit, Kenya followed suit. And always when I meet with them as the president of the African Ombudsman and Mediators Association, I would say to them, don't envy us as South Africa. Remain as a purely ombudsman. Your remedial action should be, or recommendation should be, you need to persuade those institutions, work with them until such time they understand where you're coming from. The minute then you want your remedial action, because now a remedial action is like a court order. Hence now there's also professional jealousy, or some judges thinking that I'm competing with them. I also want to be a judge. I'm not saying I'm a judge, but it's because of that remedial action. And I would say that reconsideration should be, in fact, that should be looked into. Alternatively, amend the issue of amending EMIA to have the first instance complaint in Parliament. Then when the Parliament is failing, then escalate to the public protector as far as EMIA is concerned, because we're dealing with EMIA. As far as the Constitutional Court judgment, the final arbiter, unless then as a country, I see there's a talk of revamping and looking to the constitution, whether it still serves its purpose.
Yes.
Possibly those are some of the things which we need to look into. I don't know, because it's a Constitutional Court judgment.
Well,
but again, it might not be a problem, because if a court understands their role, that the public protector has issued a remedial action, it's reviewed, taken in that spirit that I don't want to, or the public protector, because I'm left with how many months. And when you see that the public protector reached a wrong conclusion, why not go back to basics as a judge? Refer the matter back to the institution. You failed to look into the following, like what we requested with the FSP, we're going to deal with it. And I'm now blamed, or I'm charged for that. Because I was saying with FSP, I was misled by my team. Bring back the matter so that we investigate it properly. Maybe that might help. And also then allow the public protector, but it will be a useless institution where you would then give them a long process to investigate, because that will mean if we are investigating, we serve you an OD, another OD, until such time you agree. But if a person says no, because some of them have attitude and say, no, I don't agree. Even if you show them, but you violated this law, no, I'll take you on review. Because they know with this current public protector, whoever comes to court, they will win the case.
Yes. And I'm asking you because, again, maybe this is something that is not easily appreciated. Remember, the judges, we can't blame the judges. The judges interpret the Constitution. So if the Constitution says that the remedial action is binding, the judges cannot do anything about it. And we assume that's what they did in the Enquiry judgment. So that would mean the solution, you and Honorable Sokoni's solution, lies elsewhere. And that would be in a constitutional amendment. And that's why I'm asking you, because you can't die twice. Yeah, you've already been impeached for proposing a constitutional amendment.
We're still going to deal with that, yeah.
Yes, and we're still going to deal with
not amending it, but just proposing it.
Proposing, that's what I'm saying. Yeah. Now, and that's what I wanted to say, that ultimately, let's say now it's after your term, you've now handed over, and so you won't be doing this from a position of self-interest or self-preservation or trying to defend yourself from an impeachment. Would you agree with Honorable Sokone that therefore such a constitutional amendment should be proposed, or let me say debated by the country? I think let's put it at the lowest level, that the country should look into that issue if we want to preserve the benefits that this institution give to South Africa.
I think it's just debating on the issues and see, because you'd find that how it's crafted in the constitution is fine. It gives you all the powers. Then it goes with political will, but again, it still go back to the courts, SC, because if we review your judgment, why not send it back and say to you, do the proper work? Because I think instead of then piling that up and then saying we are charging you 90% of your charges relate to the court judgments and the comments by the judges. But yeah, possibly there must be a debate on that particular issue.
Yes, thank you, Chair. Yes, okay, I'm closing that issue, but as usual, if I overnight have one or two, it won't take more than 10 minutes, Chair. It always happens that I'll just check my notes, but and we may just sweep up one or two issues, but in theory, we'll be moving to something else tomorrow. Thank you, Chair.
Thank you, Chair.
Thank you, Advocate Mpofu, and thank you, Advocate Mkhwebane. I'm mindful of the fact that we have stretched this one, so so colleagues, I think that's where we're going to pause for the day, and we'll resume tomorrow at 10.
Thank you, Chair.
Thank you. Meeting adjourned.
Thanks. Sorry.
It's not me, it's him.
Recording stopped.